Supplementary list, item number 1 for delivery of judgment.
We will up the writ petition. We quash the order appointing, re-engaging. We have clarified that this is in the facts of the present case, does not mean that all appointments made by the government in other posts will be rendered.
That's correct. Great. Correct.
And we have made it clear that this is not to reflect on his competence or ability or
That's
qualification.
That's right. That was not even asked.
I agree. Can we read that judgment?
Of course.
Read for me.
List, item number 2.
May I please your lordship, my lord, the opposite party number 3 issued an advertisement for leasing out the minor minerals for 5 years, my lord. The petitioners and along with other villages
Or this petitioner's representation dated 12/10/2022 to be examined by the collector.
my lord. I lord, please.
Nayagat, and after notice to the petitioners. Petitioner and giving him a hearing, the reasoned order should be passed not later than 3rd April and be communicated to him by 10th April. The court clarifies that it is not expressed in given.
Item number 3.
None appears. The petitioner dismissed. All right.
Item number 4.
Milord, I mean, Milord, item 4, I pray, Milord, let it come next week, Milord. I will.
Why? Why, sir?
Milord, I'm not ready in this case, Milord, today. So let it come next week. I will ready.
Last time you also, in November also, you sought an adjournment, sir.
My lord,
The-
the last chance your lordship may say that at the last.
Sorry?
As a last chance your lordship may say that
No,
next.
what is the matter about? What?
Matter
So
is very
complicated.
My lord, no, my lord, not complicated. My lord, it
Yeah.
is a small matter, my lord. With regard to my lord, imposition of penalty for non-filing of the CA report, that is chartered accountant report. And the penalty has been imposed under section 54 my lord, and providing a wrong provision of the law. And the regional authority also rightly marked that there is a wrong provision of law was there, and the party was not also given opportunity of hearing, and no notice was served. Though it was set aside, but he has remanded that matter for a fresh disposal after my lord period of limitation, that is my lord 5 years, as per rule my lord 119 of the Orissa VAT rule.
No. Remand means it will still go back. The remand doesn't make it barred by limitation, sir.
And
It's only a remand order.
my lord, remand. But apart from that, my lord, I was not noticed before passing any order, my
Anyway,
lord.
now you will get enough opportunity, sir.
And
It's
my
only
lord,
been
that
sent back.
remand- and your lordship kindly have a glance that section 79 was stipulates my lord the remand, but that the remand power was not there of the my lord regional authority.
It is anyway been set aside and sent back, sir. All these points you can urge there now, afresh. It's only been sent back. You say the challenge here, the petition is to an order dated 30th June 2021, passed by the Additional Commissioner of Sales Tax, Balangir, Range Balangir, disposing of the petitioner's revision case number 210/2018-19 and remanding the matter. The sales tax officer to initiate proceedings afresh as per the law. Paragraph, having heard learned counsel for the petitioner and having perused the records placed, documents placed on record, including the impugned order, the court is of the view that it does not call for any interference since it is innocuous and not adverse to the petitioner. Full stop. There's all that the additional commissioner has done is to remand the matter to the STO for initiating proceedings afresh, in accordance with law and court. This will mean that it will be open to the petitioner to urge all the contentions available to the petitioner in accordance with law before the STO, if he decides to initiate proceedings afresh in accordance with law. With the above observations, the court is not inclined to interfere. The petition is accordingly dismissed.
Disposed of, your lordship, I may be.
All right, disposed of.
Item 5.
Obliged. Item 5, my lords, the arguing counsel is ill. I'm praying for a short adjournment, my lords.
What's the matter about, sir?
Demand comes, so cause notice has been challenged.
Yes, my lord. That's at Annexure 3, my lords. Praying for a short adjournment.
Mr. Satpathy, is it the period prior to amendment?
Yes, my lords.
18%.
Yes, my lords.
Retrospectively, you have
Yes,
applied
that is what.
Yes,
pursuant to
yes, my
advance ruling, and
Yes, that has been challenged.
one of the cases we have granted interim order.
Yes,
in
Yes,
the
my lords.
Other,
yes, that has been enclosed in the petition itself.
Where is that?
That is starts from phase.
(156).
Yes.
When is it listed? You say notice, Mr. Satpathy accepts notice for opposite party number 1
Milord,
or 2 and 3,
2 and 3.
and Mr. Mishra for 1.
No, Milord, Mishra is not here, Milord.
Oh,
Only the
not
Milord.
yet.
Central-
All right.
Central.
Only sent.
Reply within 8 weeks rejoinder for the next date. List along with writ petition civil
3181/20.
3181 of 2022.
3181 of 2022 on just the date you'll have to find out. 3181.
next.
Interim order, my lords.
In the meanwhile, no coercive action be taken against the petitioner.
Great.
Well, same order may kindly passed Same order may kindly pass 34, 62, 63, 64.
Oh,
Same matter.
34?
34, 62, 63, 64, 65, 66, and 68.
Oh, I see.
All of a sudden he has appeared ballots in virtual.
Oh, let it calm, let it freeze.
Why you are not pocketing here? And you are a very invisible man like Bajrang Bali. You are over.
He has permitted you to take an early cup of tea.
Your argument he has considered. So he doesn't want to make this insufficient again.
Makes me total confused, my lord.
My lord, it is always difficult to face my learned senior. So your lordship, always we are trying to avoid.
He always, he's just like Bajrang Bali. Appears in. So who is by?
Which are the numbers, sir, Mr. Chibanka?
34,
Huh.
62, 63, 64, 65, 66, and 68.
All right. All right. We'll give a date then, just along with all of that. On 26th April.
I think I have to file a counter also.
Oh, 21st August. All right.
21st August
2020. So neither Justice Singh or me you can pay. You can face.
That will be a great period, my lords. Green period. I think I have to file a counter, my lords. I'll check up.
All right. All right.
Result. They have filed a counter. I'll file a result.
All right. All right.
You fall counter.
Right. So, right.
Item number 5 is similar to item number 34, 62, 63, 64, 65, 66, and 68.
Yes. Yes.
Item number 6.
May I please, your lordship?
Yes.
Lordship, item number 6 and 7, your lordship. Humbly pray, my lords, for withdrawal of appeal, means liberty to file appeal against assessment.
All right. Both petitions permitted to be withdrawn.
Both the matters, my lord, I am
Memo of appeals taken on record for the respondents, opposite party.
my lord.
See, council permission, the petition is permitted to be withdrawn with liberty to the petitioner to file an appeal in accordance with law. If such appeal is filed not later than 1st March, accompanied by an application for condition of delay, explaining the delay on account of the pendency of the present petition, it will be taken into account and dealt with in accordance with law by the appellate authority. If the court clarifies it has not expressed anything in the matter, the originals will be returned subject to being substituted to attested photocopies.
Item number 8.
May I please the lordship? The lordship, the petitioner has challenged the order of the first appellate authority under the GST.
10%.
10%.
All right.
Your lordship may kindly pass similar orders in item number 9 and 36. Highly obliged.
And list on 28th August.
Item number 10.
The brief appears to be a little bulky, but the point is very short, my lord.
The advantage in paperless court is we don't know whether it's bulky or small.
Oh, your lordship is holding. I'm sorry, Lord. I'm sorry.
No. In fact, you should become paperless, your office.
In fact, Lord, I'm trying to.
Your son will be able to catch on.
Yes, Lord. He is more rather acquainted with. They are all.
Yes, we can do that. Yeah. They can also use. You're right.
I'll learn it. In fact, from the way your lordships are dealing with these matters, I'll try to learn it.
No. So Kerala, they've gone to the next level. We want to do that here.
Lawyers also.
The lawyers also, no, they're keeping 2 monitors on that side, uploaded with the SEC. So lawyers can also use that SEC by touch of the.
Immediately therefrom they will.
So you can cite the same SEC and we can see it here. No need for you to bring photocopies.
It will say paper also. It will say paper also, right? So here I'm challenging the sale notice. The sale notice at page 17, annexure 1. Lordship will find the date of sale is fixed to 2nd of February 2023. But I have a very short point here. Page 214, your lordship would kindly turn to. They raised me a demand that I am a defaulter for this amount, 214 annexure 14. Lordship, see second paragraph. You are therefore instructed to deposit area outstanding government dues 44,97,000 so and so rupees so and so. Towards utilization fee of MGQ Mahaflar of the SOPs 2021-22 and required fees for renewal of license fee Bethnoti Ragha Sorubhila Outstill SOPs from 22-23 at an early date and produce copy of challenge showing credital of the above amount before the undersigned for taking further action. But your Lordship will find that there is no date fixed. Still then, my Lord, I say that I am a defaulter and I am willing to pay it within the date fixed and as would be suggested by my learned friend, entire amount I will pay. But let them not hold lottery for myself, my Lord. I will pay the entire outstanding as demanded by the government.
By which time will you pay?
Time
It has to be before the date fixed for a lottery.
2nd of
2nd February is the date fixed.
Otherwise,
Otherwise,
date
By 31st?
by 31st.
31st January.
No, 31st will be little, my Lord. Give me little.
No, but the date of auction is 2nd February.
Yes.
But they are not finalizing it. Let the auction go on before finalizing.
No, no, but why should
No,
why
no,
should
why
it
should
not
the
come?
auction will, if
Then
you are
he will ask for
depositing-
refund of that bid money and all that.
Yes. As your Lordship, Lord, before 2nd.
No, by 31st. You see, Mr. Rathar states that the petitioner is willing to pay the amount specified in the impute demand notice dated 29th August 2022, that is rupees 44,97,750. Sorry, 570.
5/7 with up to date interest.
Interest, like.
Interest.
Interest, there is no interest.
No.
After August
No, there is
till
no,
January.
Mr. Mahanti knows it, there is
No.
no interest.
On or before 31st January 2022, 23.
Right.
Full stop. Paragraph, it is directed that subject to the petitioner complying with the above assurance, the auction proposed for 2nd February 2023,
In respect of Bethanati, Ragada and Swarup Villa.
Those
in
three,
respect of the Bethanati, Ragada and Swarup Villa outstill liquor shops
For the year 2022-23.
for the year 22-23 shall be
Kept in abeyance.
abeyance. Full stop. Paragraph. It's made clear that if the petitioner does not adhere to this assurance, the auction can proceed as proposed.
that's fine.
The petition is disposed of.
Grateful. Lordships are disposing of the matter.
Yes.
In that case, Lord, I have a small grievance in this matter also.
Ah.
With regard to that closure period of the COVID period adjustment.
That you can separately petition.
That's the reason it's here also, and pending petition is there. If your Lordship give me an observation, I'll also approach the authority in that regards. They will consider.
But that is a separate writ petition you
That
already
is a
filed.
separate.
That's pending, Lord. That's pending.
When is that coming up?
Lord, no date is fixed. No date is there. I can give the number. It should
You mention it, then we'll take it on board.
Yes, Lord. Yes.
You mentioned that.
Yes. I'll make a mention. But those names, let there be any confusion appearing in the notice itself.
May I pray another thing? Your Lordship may direct to upload this order today because he has to produce this, the 31st
Correct.
is.
Upload it, yeah, to date.
Yes, Lord. Grateful.
Item 11,
May I please, Your Lordship? In item 11, Your Lordship, the order of honorable single judge under annexure 10 is under challenge, Your Lordship. That is page 58. The brief factual background of the matter is, Your Lordship, the present appellants, they are working as junior lecturers in +2 colleges, Your Lordship. Now, they have been appointed in the year 2014, Your Lordship. Now, after continuing for more than 5 years, Your Lordship, in the year 2019, the government decided to terminate their services, not to extend their services, Your Lordship. Now, subsequently, they have come in a batch of writ applications. Now, the Honorable Single Judge in the batch of writ applications dismissed the same. Now, against the very same order of the Honorable Single Judge, a batch of writ applications were preferred. Now, my Lordship, kindly see page number 58 of annexure 10, Your Lordship. The relevant portion is page 59, Your Lordship.
Yes.
I will read from para 3, Your Lordship. The fact involving the petition is that petitioner was appointed as ad hoc lecturer in degree college by annexure 2 series. Filing this petition, petitioner is claiming regularization and also challenge the advertisement by annexure 9. For petitioner accepting the offer of appointment as ad hoc employee with specific condition by annexure 2 series and also accepting the last conditional extension by annexure 8. Further, not challenging the advertisement number 18 of 1920 at the threshold is now.
So what happened to that batch of writ appeals?
Yes, Your Lordship. The matter was
That has been referred to third judge.
We'll await the decision of the third judge.
Yes, my lord. In view of difference of opinion.
Right. At the request of counsel for the parties and awaiting the decision in the batch of writ appeals, including writ appeal number 234 of 2020. The present petition is directed to be listed on 9th August.
I'm grateful, Your Lordship.
Item 12.
I pray for 10 days time to remove the defects, my lord.
Seven five automatic only. Your Lordship. That doesn't arise 7.5 OET Act.
This is also
Automatic.
covered by your lordship decision in Bajaj Auto Limited, my lord.
No, that is different, Your Lordship.
So, no, in this case, penalty has been waived, only interest remains because I have paid the tax as per the Supreme Court judgment. I have not paid the tax as per the judgment of the Honorable High Court in my favor. Thereafter, the Supreme Court judgment has come. And after the Supreme Court judgment, I have paid the tax. And the penalty has been waived by the tribunal. Only part remains is interest.
That issue is pending, Your Lordship. Your Lordship, so far as what happened in this case, just now I have received the copy, but so far as the anti-tax is concerned, Your Lordship, here in Reliance Industries case, Your Lordship, this Honorable Court has declared intravirus and parathetic. Against that, Your Lordship, Honorable Supreme Court has, in the interim order, Your Lordship, 2010 interim order, Honorable Supreme Court has directed that to pay 33% and from the payable in the return. 33%, Your Lordship, the balance will be state till disposal. And against pursuant to that order of Honorable Supreme Court, this Honorable Court has passed recognizing that order in this case, Your Lordship, and the petitioner has paid the amount. Subsequently, Your Lordship, in the meantime, Your Lordship, Honorable Supreme Court has allowed the state's SLPs by directing that justified the levy, Your Lordship. For that reason, Your Lordship, the Honorable, the Learning Tribunal has deleted the penalty pursuant to Your Lordship and deleted the penalty, but levied the interest. So that interest part, Your Lordship, my Lord and Senior says that it is covered by in that Bajaj Auto Limited, but that is not covered, Your Lordship. It is a separate issue.
My learned friend is factually wrong, my lord. Your Lordship may say page 3. There was a specific order in my favor that was not challenged before the Supreme Court. Your Lordship may say 5529 of 2007 was passed in my favor as per the Honorable High Court Division Bench decision. That order has not been challenged, so insofar as the petitioner is concerned before the Honorable Supreme Court. After the Supreme Court judgment in the Reliance Industries case, I voluntarily paid tax. That was not taken into account by the Sales Tax Tribunal. Only Sales Tax Tribunal retained the part of the interest and tax. But I paid the tax subsequently because this remains to the period exactly during that period, my lord. I paid the tax subsequently pursuant to the Supreme Court judgment. Only part now remains with regard to interest. And that is covered by the Bajaj Auto Limited, my lord.
No, Your Lordship.
Correct. Whether before or after. No, Bajaj Auto may be not applicable to you, sir.
Here, my lord, as my learned friend says, Supreme Court interim order was not applicable to me because I was not a party there. And the judgment in the High Court stood in my favor. After the final judgment in the Supreme Court, my lord, I paid the tax after the final judgment in the Supreme Court. And the tribunal has not also taken into account that I paid the tax that time. That time also I had not paid the tax, my lord. I paid subsequently to the Supreme Court judgment. And tribunal only retained the part of the tax and the interest part of it. That interest part now, since I have paid the tax, only interest part that is covered by the Bajaj Auto.
No, not covered, not covered. Even that is not covered against that Food Corporation of India and Bajaj Auto, Your Lordship. More so, Your Lordship. Because Calcutta Jute is there, many judgments are there, and in that case, those cases, those bonds cases, Your Lordship, many judgments are there. This is not applicable here, so far as the anti-tax interest is concerned.
How is it not applicable, my lord? What is the difference, my lord? He doesn't say that. He says only says it's not applicable.
Your Lordship may admit this revision. Just now I have received the copy. It is for the first time. Your Lordship may admit and question of law be framed and may be tagged with that case or any further next date may be fixed by
I admit the following question is framed for consideration. Was the department justified in raising a demand for interest under section 7(5) of the Orissa Entry Tax Act 1999 (OET Act) against the petitioner on the tax amount admittedly paid by the petitioner after the judgment of the Supreme Court dated 28 March 2017
Your Lordship.
In the
State of Orissa versus Reliance Industry.
in state of industry, Orissa versus Reliance Industries Limited. Question mark.
I have not even paid the tax. during that time. Tax was also not paid that time, my lord.
Anyway,
Yes.
we've just said interest. We framed the question only on interest. All right.
Yes.
List on. When are those matters coming?
2nd February, Your Lordship.
2nd February.
2nd February.
Oh, I see. List on 2nd February. All right.
Obliged, my lord.
Item 13,
Your Lordship, may I please, Your Lordship, item 13 is that 40 to 5, Your Lordship.
Notice returnable 16th August. Dispensing. IAS allowed.
item 14,
Your Lordship, item 14 is 16 days delay, Your Lordship.
Delays
And
come.
9C5 penalty.
So you accept notice.
Hello, in similar matter, in the impugner, the opposite party also filed a writ petition, revision petition before my lords actually, challenge the root of the demand, my lords. That is whether the minerals were covered under entry serial number 59, which is posted before my lords on the 19th of April, your lordships.
19th of April.
My lords.
Notice returnable. He accepts notice. 19th April. List along with STREV.
I will give the number, my lords.
All right.
item 15,
May I please know? I have solved the copy, 10 days delay.
Just now.
Delays condoned, dispense
Yes,
with
just
that's allowed.
And the question, Lord, question, Lord, I have formulated, Lord, whether the tribunal justified to levy tax on the ultimately sold to the ACZ unit as a raw material. And second is, Lord, whether the sold coal tar pit is a scheduled goods under the Entry Tax Act. And here you lordship see, I have not all the goods are directly sold by my contractor. I mean the person who has sold transfer the goods for job work for converting to sold coal tar piece, and ultimately he sold the goods to the ACZ unit, that is Vedanta Milord. And we have all the central excise also give me the permission for the same which has enforced. If your lordship see the letter of the central excise authority and the bills are directly sold to the ACZ unit. Therefore, we have two grounds, whether that the sold coal tar piece will come under the purview of scheduled goods, and second one, goods sold by them directly to the ACZ unit.
So Mr. will frame the questions.
Your Lordship.
All right. Admit following questions are framed A, B, C, and D. Pages 10 and 11.
Your lordship, that 10 days delay may be condoned. 10 days delay, Milord.
Delay condoned exemption.
And Milord, annexure 2 and 3 may be dispensed with.
And this on 17th August.
Much obliged.
item 16,
Your Lordship, item number 16. Here 43 and section 10, both the 10, 16 and 17, Your Lordship. 16 is 43 and 17 is 10. Your Lordship, here is 85 days delay. Your Lordship can reject on delay ground. Your Lordship, here it is covered by Your Lordship judgment against the department. So far as not so far as penalty, Your Lordship, but so far as independent opinion, Your Lordship. Your Lordship, this is the order.
Indure.
Your Lordship, this is the order 2 Knots India Private Limited, which Your Lordship has passed. That is 12-8. Also, in another case, 43, also the same finding, Your Lordship, so far as that independent opinion, subjective satisfaction should be there.
Correct. All right. In view of the judgment dated 13 July 2022 in STRV 26 of 2013, bracket 3 Nuts India Private Limited versus State of Orissa, the court declines to interfere with the impugn order of the tribunal in the present case and dismisses.
And also another 43, Your Lordship. Here, since counter has not been filed, but the same finding is there.
Right. And the order dated 8/12/2022 in the writ petition civil 8236 of 2017, bracket Messrs. Shree Industry Balashur versus the sales tax officer. The court declines to interfere with the impugned order of the tribunal and dismisses the STREV. The dispense with this allowed continuation of delay condoned. Next one, sir, 17.
17 is 10, section
Same.
10,
10.
anti-tax.
How?
The same reassessment.
All right. For the reason stated in the order passed today, dismissing STREV 33 of 2021, the present STREV, which pertains to Orissa Entry Tax Act, demand under the Orissa Entry Tax Act, is also dismissed. Here again, delay condoned, IA allowed for dispensing.
Item 18,
Non-P is dismissed.
item 19,
19, let's see, it is also covered by, let's see, here the central sales tax, the assessment is under Central Sales Tax Act. Penalty has been levied under section 12(3)(g), and let's see, already deleted that penalty so pursuant to the Commissioner circular, but levied the interest under. So the question of law is here that the levy of interest, let's see. But at page 36, the question of law, question number 1 and 2, the levy of interest under section 8(1). And in Bureau Files Limited, your lordship has already decided in that case.
Question 3.
Your lordship.
Question 3.
Your lordship. Question number 2 and 3. 3, your lordship.
3.
Your lordship. 3. The same thing has been happened here. In the Bureau 5, your lordship, the Honorable Tribunal, Learning Tribunal.
No, but your notice has to go now.
Your
notice confined to question number 3, which reads as under 37 and 38. Notice returnable 10th August.
Yes.
item 20,
Delay. What's the delay, sir?
My lords, 20 I am not pressing, my lords.
Dismissed is not pressed. All right.
item 21,
21, my lords, delay is there. Your lordship may grant 1 week time. My lords, here is that the issues are not decided at all, my lords. The claim amount involved is more than 1 crore, my lords. Lordship may.
What's the delay?
No delay. Here, no, there is no delay.
All right. Notice returnable. IA is allowed. Notice returnable 17th August. He accepts notice.
item 22,
My lord, in item 22, question of law will properly not been permitted, my lord. I may be permitted to amend the question of law, my lord.
22, CMAP.
DDP plus 22. My lord, in item 14, that is the STRV 38 by 21, my lords. Item 14, that is STRV 38 by 21, my lords. Grateful, my lord. 38 of 21, my lords. See, item 14. Grateful, my lord.
item 23,
May I please move first? The questions of law, my lord, this is page 18. And I'll be confining my prayer to frame question number B, my lords. And this is directly covered by a lordship judgment, my lords. Because the
shortage of stock.
No, my lords, this Keshav Automobiles. So here your lordship will appreciate if your lordship would kindly turn to page 40 of the brief, my lords. That's the tribunal's order, page 40 of the brief.
BB. Okay. All right.
The period is 1/4/2010 to 31/3/2011 minutes. And if your lordship would kindly turn to page 47.
Yes.
Paragraph 6, my lords. Unfortunately, my lord, the amended provision of section 39 is quoted as subitem 2, my lords. And this was a period prior to 1/10/2015. And quoting a wrong, an amended provision which came after.
As if it has retrospective.
Milots.
The
And
tribunal
there,
has been.
milots, there the tribunal comes to a conclusion at page 50
Anyway, it's covered by Keshav.
It's covered by Keshav. I've already given your lordship, sir.
Or admit the following question is framed for consideration. B for Bombay. Question B at page 18. The above question stands answered in favor of the assessing against the department with the judgment of this court in Keshav Automobiles, which has been affirmed by the Supreme Court in Rati Steels. The question is answered accordingly, and the imbue order of the tribunal and the corresponding orders of the first appellate authority and the assessing authority are hereby set aside. The revision petition is disposed.
Any extra amount, my lords? Any extra amount paid, my lord?
It will be open to the petitioner to seek refund of any extra amount paid in accordance with law.
I've given 2 copies of Keshav, my lord, in the brief itself.
All right.
Greatly obliged.
Right.
Item 24.
Before my lords, my apologies for not appearing earlier.
When did you not appear?
Not appear, my lord, missed the list. Here the merit in the merits. The short date chart.
111. This is the problem, sir. This was not the day on which you should have not appeared.
Well,
I'm not entertaining.
I have earlier appeared.
On these dates, I expect you people are senior members of the bar. If you
My lords,
start doing this, then
my
what
apologies,
is
my lord,
left?
that's why initially I said, because I missed the list. It's not that because of the strike or anything. Because I have a merit in this matter. My lords, your lordship may consider this. Because
What is the merit?
My lord, kindly see the date chart. 10/8/2008, an advertisement was made for one regular post of Assistant Professor Botany General. 2 were made actually. One was ST. There is still only 1 person. A merit list was prepared, my lord. In the merit list, there are 4 persons. The petitioner original respondent number 1 was at serial number 4. Now, Dr. Chinmay Pradhan was appointed on 9/7/2009, being serial number 1, my lord. My lord, in the meantime, thereafter, 24/2010, another advertisement was issued for a post of Assistant Professor Botany, which was reserved for women. Now, on 30/4/2010, Dr. Chinmay Pradhan resigned from the post. Now, petitioner claims that advertisement 24 should not have been issued at all. And since a vacancy was created by resignation of Chinmay Pradhan, she should be absorbed in that. So now the law is that I've given that judgment.
Confined to the facts of the case. You say, while the court is not inclined to recall its order dated 1st November 2022, it's clarified the judgment of the single judge, which was subject matter of the appeal in writ appeal 395 of 2017, will not be treated as a precedent in other cases, for other cases.
Yeah, Lordship, you kindly see the judgment I have given 2010 directly on that point.
It's all right.
My lord, kindly, my lord.
All right.
I will not be doing justice to my client.
No, it's okay.
Yes.
Item 25.
Next week, man.
I pray for next week, man. For what?
Lord, I'm not feeling well, my lord.
No, this is all, it's a what, RERA matter.
Yes.
You should go to the RERA tribunal.
No. That is not, I'm not challenging any order of the real estate authority. Here, my lord,
No, you're not challenging. You have a grievance about non-issuance of occupancy certificate.
Not allowing, your lordship kindly call it after.
No.
Day after tomorrow, my lord, I will satisfy.
What's the matter, sir?
My lord, here, my lord, my prayer is, they are not, opposite party are not allowing me the registration of the sale deed. On the ground that I have stated at page 11 that another writ petition is pending before this honorable court.
No, that's a different matter, sir.
That is relating to utilization of common area. Your lordship, day after tomorrow, your lordship kindly call this. Day after tomorrow.
When was your project completed?
My lord,
completion certificate from the architect was issued on 19 May 2020. It's not with the competent authority. You're saying competent architect.
Your Lordship, kindly.
It has to be competent authority, sir, not architect.
Day after tomorrow, my lord.
No, no. That circular is already there
Yes, my
now.
lords, that circular is already there. The cutoff date is there. So the projects which have received the completion certificate prior to
Already.
that cutoff-
This doesn't seem to be that. This seems to be afterwards.
Under
19/5/21.
19/5/21.
Under Annex
That is no less. That is one.
After the RERA Act came in.
As 1/7/2021 is when the RERA Act came in. This is 19/5. I'll just have to check whether.
All right. When are those matters coming up?
As, those matters.
That is on 23rd March, ma'am.
23rd March.
23rd March, ma'am.
No, 22nd March.
My lord, sorry, ma'am.
Okay, list on 22nd March along with WP Civil 18799 of 2021. All right.
Item 26.
Wait, your lordships. Dear my lords, notice was issued on 27th of October 2014, my lords. And unfortunately, the council, because of the death of the council, conducting council, it was dismissed for default on 19th of December, my lords.
All right. You say for the reason stated, the order dated 19th December. In writ petition civil 11967 of 2014 is recalled. As I said, writ petition is restored to the file. The CMAPL is disposed of. In the main writ petition 11967, this petition has been restored today by an order passed in CMAPL 40 of 2023.
The interim order.
There's no interim order.
Yes, earlier interim order was there, my lords.
No,
Yeah.
no.
Yes, yes. Lordship will kindly.
If you demand.
Yes,
Okay.
yes.
The interim order is restored.
Yes.
You have to give a copy to
Sir,
Mr. Mishra.
I'll give, I have already served 2 copies and now.
No, of the writ petition, 2014.
Well,
The copies of the writ petition we served on Mr. Mishra today itself. This is audit assessment, 42.
no, my lords.
No, your lordship.
No, this
CST,
is CST.
Yes, actually. All right. List
That's
of-
why fix a date. I'll.
All right.
It is appealable, your lordship. My lord and senior can file
You
appeal.
file a counter. There is a.
Already-
Yes, you are. Very, very nice method you have.
My lord has already
No,
held that 12 penalty is
that
not
is a-
variable. So
No,
it is in favor
not
of
a
you.
question of penalty. It is a question, my lords, whether the amendment brought into the act with effect from 28th of February 2005 makes it mandatory or not. That is the law to be decided by this honorable court. It's very clever.
Subsection 4 of section 5.
Yes, I'm much obliged.
13th April.
30th of April.
13th April.
13th balance. Much obliged.
Right.
Item 27.
Encroachment.
Item 27, my lord, and for the petitioners. Now, the petitioners have filed this PIL.
Encroachers are not made parties, sir. You have to make the encroachers parties. Have you named them in the representation at least?
Yes,
Yes, my lord. I have named them in the.
All right. Petitioner's representation, bracket annexure 7, shall be examined by the Tahsildar.
That's-
No, you've not made him a party.
Well, the representation is to the
You've not made
collector.
him a party.
The Tahsildar is not made a party.
All right, by the collector Baleshwar. And after notice to the petitioners and the encroachers who have been named in the representation. And after giving them a hearing, a reasoned order shall be passed not later than 1st May 2023, and we communicated to the parties within a week thereafter. The court clarifies it does not explicitly mean the matter. All right.
Item 28.
Till lordship that notifications are not challenged, lordship granting me liberty to lordship constitutional action.
All right. Counsel for the petitioner seeks leave to withdraw the present petition with liberty to seek other appropriate remedies as may be available to the petitioner in accordance with law. Disposed of is withdrawn with liberty as stated.
Item 29.
There is small mistake. It should be 21 instead of 2017.
All right. For the reason stated, the application is allowed the corrected order be issued as direct, as prayed for.
Item 30.
Item 30, 31, 32, 33 are similar to item number 4. That's 65-2 penalty.
Well, item 3, that item 4, item 4. And here, my lord, your lordship may dispose of in the same line and stating that, my lord, all the contention may be raised before the assessing authority.
All right. So same order as in 4.
My lord.
31 to 33.
One line maybe, my lord, I will urge all those contentions before the authority, my lord.
That is obvious, sir. Yes.
Item 34 is similar to item number 5. $35.
May it please, Milots. No, the short point involved in this matter, Milots, is that I asked for certified copies of the Milots order sheet and the search warrant. They are not being provided.
What your instructions? Who's for the other side?
Your lordship, in this matter, Mr. Tusargani Sarpati is appearing. Today itself, we received the copy, your lordship. We will take time to receive.
Counsel for the respondent seeks time for instruction. When is the next matter date given to you in the adjudication proceedings?
No, Milots. Here, Milots, I have to file an appeal before the CSTAT and execute those documents. Milots, I'll file the appeal in the meanwhile. But Milots, as and when I receive the certified copies, I'll take additional grounds of appeal.
Then we'll dispose it of asking you to give certified copies.
Lordship,
All right. Counsel for appearing on behalf of the opposite party department seeks some time for instructions. At his request, list on 7th February.
Very good. Milots, can it be 8th? 8th. Great. Great.
Item 36. Item 37.
My lord, one time kindly be allowed for removal of defects. 8260. 37.
This is against the first appeal order. Is the first appellate order, sir?
My lord.
As I said,
I've already made the payment of 20%.
20% already paid?
Already paid.
So you said taken on board because the second appellate authority is not being constituted. Notice, he accepts notice. Reply in 8 weeks, result of the next date. In the IA 685/2023, Constitutional petition states that the entire 20% of the demand tax has already been paid. In that view of the matter, during the pendency of the petition, no coercive action should be taken against the petitioner. The IA is disposed of. Main matter is in this law.
So let's see 20% along with 10%.
No, 10% along with 10%.
10% you have paid along with another 20%.
Another 10%.
Another 20%.
10% plus 20% of the demand. List on 14th August.
Item 38.
38, Milots, same as 37. Milots,
Paid 20%.
No, Milots, I've paid 10%. Milots, I'll pay 20%.
Right. Subject to is paying 20% within 4 weeks. No coercive steps should be taken against the petitioner. The IA is disposed of. Same date, 14th August.
Great.
Right.
Item 39.
The office note has been produced. The correction be carried out. And the fresh order be uploaded. Right.
Item 40.
My lord, item 40, my lord. Here the petitioners filing this writ petition challenging the action of the excise authority not refund the license be deposited during the closure period, my lord. My lord, the petitioner's representation is pending at Annexure 6, page 26 before the collector Moyurbhanj, my lord.
All right. Petitioner's representation, bracket Annexure 6, shall be examined by the collector Moyurbhanj. And after hearing the petitioner, a reasoned order shall be passed thereon not later than 3rd April 2023, and we communicate with the petitioner within a week thereafter. It will be open to the petitioner if the decision is adverse to it to seek appropriate remedies in accordance with law. If to him, you say, the court clarifies it is not expressed in even the matter, petition is disposed of.
Item 41.
May I please your lordship? Lord, earlier rejection order by the government for grant of on-shop license was assailed by the petitioners, and your lordship was pleased to quash this same order with a direction to the state to reconsider, because the point was that that earlier rejection was not a non-speaking order, and secondly, the objection which has been received after the band of statutory period of 15 days, that hit by the rule 33(2), as your lordship has already held in a one Gitanjali South case. Again, government consider afresh same point. Again, they have rejected.
Without reasons.
Without reasons. Even if your lordship's order has not taken into care, I will take instruction. I will file count. Lordship, may I submit one thing? 31st March, my the validity of application is still 31st. So must before that, you also may fix a date so that.
Notice, Mr. Mohanty accepts notice. Paragraph. Reply be filed if any within 4 weeks, rejoined up to the next date. List on 1st March.
My lord, obliged.
Item 42.
42 kindly taken up after lunch.
After? After lunch? Pass over.
Item 43.
None appears dismissed.
Item 44.
My lord's name of Mr. B.K. Das may kindly be recorded for item number 43 for State Information Commission.
All right, respondent. For the respondent. None appears.
Item 44. Item 44 may kindly be not placed.
Not pressed. Disposed of, not pressed.
Obliged.
Item 45.
None appears dismissed.
Item 46.
Yes, maybe. 106.
Similar order.
Well, unlike Mr. case that has been stayed before the honorable apex court.
When is it coming up, sir?
It's fixed to 1st February, man.
Okay. Same order list on 1st February. All right, memo taken on record, dismisses the charge.
Item 47.
Similar matters, as issued.
When are they coming up?
On 24th April, my lord.
24th April.
My lord.
Same order, 24th April. All right.
Item 48.
Please, my lord. My lord, in this case, my lord, the appellant challenging the order dated CU 11/2022, my lord. Honorable single judgment wherein the dismiss the claim of the appellant, my lord, with the remark that the since almost 1 year has been already been passed, my lord. In the meantime, the court have find no scope for entertaining any such a dispute involved in this case, my lord. The fact of the case, my lord. The petitioner, appellant, my lord, is working as a sweeper, my lord, on daily wages basis since the year 2009, my lord. And the continuance of the more than 11 years of the service, my lord, is eligible for the regularization of the service. When the authority, my lord, has not considered his case, my lord, he approached before the honorable court, my lord, by WPC number.
No, this is the second round of litigation, sir.
My lord.
Ah. Actually, it's on latches that the single judge has disposed it of. What is the reason for the delay?
मैंने तो प्लेन Opulent is not coming under the government scheme, my lord.
No, delay in filing the second writ petition, sir. The single judge has said permission was granted to you on 29/11/2019. He has chosen to come to the court only on 3rd November 2020. What's the reason for the delay?
Plaintiff, my lord, is a poor and uneducated person, my lord. So that's a communication.
Poor and all. He has come to court once that IA was disposed of, giving liberty to file a writ petition. After that, the letters were poor and all. The result of the impugned order dated 3rd November 2020, passed by the single judge, in dismissing the appellant's writ petition civil 23978 of 2020, reveals that it was the second round of litigation. Full stop. Earlier, the appellant had filed WP number 22400 of 2016, in which on 29th November 2019, while disposing of IA number 9664 of 2019, filed in the said writ petition, the learned single judge observed as under, take from quoted portion in page 11, paragraph. Despite such liberty having been granted, the petitioner filed the second writ petition almost a year thereafter. When it came up for hearing on 3rd November 2020, the learned single judge declined to interfere, citing the delay as the reason. Paragraph. Concept the petitioners are able to explain convincingly why the appellant waited for almost a year to file the second writ petition. Full stop. With no proper explanation forthcoming, the court is not inclined to interfere with the impugned order of the learned single judge. The writ appeal is dismissed.
Item 49.
59. 49.
Item 49 and 50. These two are. I missed yesterday to include these two.
Parida matter.
Sarat Parida.
Sarat Parida.
8th May.
So this is only these two or another big list?
No, but so far the 2022 matters we have prepared at least.
Correct. Same order. 8th May.
Item 51.
If 51 were the opposite parties, respondent.
52, 52.
Yes, sir.
51. Sorry. Item 51.
I have 52.
51 none appears to the appellant. He appears for the opposite parties. Dismissal non prosecution.
Item 52.
52 in this case, this is a prior to the resolution. But they are not filed counter in this case.
It stands covered, I think. I've recently also given another judgment, I think.
Your lordship's judgment will not.
Correct.
My lord, the counter affidavit is there.
Ready?
Ready. It is in the draft stage. 1 week or 10 days time.
So IA has filed for extension of time for filing counter.
Yeah. But I find the draft counter affidavit is already on record.
Oh, all right.
If it's draft, it's draft, sir.
No, we'll finalize it and we'll file it within.
Whatever. Last opportunity to the opposite parties to file the replies. On or before 1st March?
5th March.
No, 1st. 1st March 2023. Interim order to continue.
Interim order to
continue. Yeah. Rejoinder if any for the next date.
53 is relating to water tax. There is some prayer that now they are insisting on an agreement in interpreting a clause which is not in the statutory form. That is the additional point. So I have sought for a direction to.
You here again counter not filed?
Yes, in this case, we have filed.
They have filed the counter.
But
So
it's not
same-
come on record.
Reason that the same date may be fixed.
All right. You should simply say list on both matters. 21st August.
Interim
People wanted to continue. Right.
21st August.
Yeah.
The earlier case, that is past
Both, I
March.
think both can come on the same day. Then the counter be
Both the
filed
cases
order
can be taken up on 1st March.
that interim order is against you, is it?
Yeah, both the
Yes,
cases.
in both the
order-
cases, interim
Actually,
orders are against.
21st March, sir. Both cases 21st March.
Because they didn't prefer any claim before the order, it is covered. by
21st
a
March.
transition.
Yes, both matters 21st March.
Item number 52 and 53 adjourned to 21st March.
Clarified everything.
Obliged.
It's now covered, Mr. Monty.
Yes, ma'am.
All matters, unless you've taken it to SLP.
And they were-
We have to file a counter.
They want to go on record. They want to go on record, my lord, because in case lest a responsibility is fixed.
All right. I see. I see.
For admission tax matters, item number 54.
I'm sorry, my lord.
Or
51.
none appears for the petition.
51, I could not.
51.
I could
Tell us.
I could not come on time. There is some delay in filing the writ appeal. But the entire grievance of the petitioners is that they are the candidates for the constables. And
What's the delay, sir?
80 days.
80 days. Okay. Cut-off mark, sir.
no cut-off mark, that was not the case of the either part. That's my stand in the writ appeal is only that. Cut-off mark, that is only an oral statement made at the bar and nothing has been produced, no counter, I had no scope. After all, what all I want is I must be considered, that's all. Because there was
But
280.
if you have scored 63 and cut-off was 64.
No, 64, that has been reflected in the judgment, impugned order, but that is never stated by way of any counter or anything, nothing. I didn't know about that. Straight away at
Still,
the time.
if it is there, it is there, sir. Unless you say, no, the record shows a cut-off mark or something else.
But the case of the petitioners is something different than the cut-off mark is. What has happened? 284 posts were there. And out of that, 24 posts were for scheduled tribe. Different zones. So far as there was some selection and I was in the merit list of 31. So they have taken about 24 people or so. Thereafter, what happened? By another circular, they have taken another 30 persons from 3 different zones. So 10 from the zone of Bolangir, from which I have also appeared, from the merit list. From there, 6 persons have joined and 4 did not join. I said that please consider my case as per the merit list, so that out of the 4 posts, I don't want an appointment. At least my cases can be considered. That therefore that is differently standing in a different foot. So far as main interview of 284 concerned, cut-off date, if it is there or not, also it will become academical now, because thereafter they have taken 30 candidates from out of the merit list. There only I have said that my case may be considered. And out of merit list, those 30 have taken, 4 did not turn up. So that remained vacant. If that is vacant, we are 3. That is only to be considered. Your Lordship may condone the delay and direct them to take instructions, my lord.
No one appearing on this side. The notice never went in this.
No.
Oh.
Because of this COVID, my lord, in 2020, I filed it.
Some defects and all are pointed out.
That I will remove, my lord. I will find out the defects.
You say counsel, sorry, you say list on 14th February, defects be removed in the meanwhile. All right. Copy of the application be served on standing counsel for the opposite parties. That's what, nothing, just giving a date. Will all remain.
Item 55.
May I please, Madam? Though, my lords, the petitioner in this application has challenged the constitutional validity of section 12(9) of the Orissa Sales Tax Act. Whereas now Orissa Sales Tax Act is repealed, Orissa value tax is repealed. Now we are on GST, this judgment also. Whereas what has happened, the writ petition, this pertains to the period belows 99-2000, and for the immediately preceding period, now the tribunal or the very, in the case of this petitioner, has the full bench has passed order holding that 12(9) is not applicable at all. The circumstances, because the facts are same. Applying the same facts, full bench of the tribunal now holds that the ingredients of 12(9) having not been satisfied, so you can't apply 12(9) in 12(8) assessment and raise the demand. So my lord, whatever I have examined, my lords, this has not been challenged also by the state before this honorable court in tax revision. So it has attained finality. So without taking much pain, because I am ready authorized to address my lords on constitutional validity, because authorized also, if your lordship will see prime emphasis, the provision itself 12(9) is a draconian. But to speak the list, it can. The deeming provision, mirrors,
rule of consistency, you say.
Yes. So therefore, what I am humbly submitting is instead of burdening your lordship with so much of mirrors arguments on constitutional validity at this distant point of time, if this can be accepted, then probably that will serve the purpose. And secondly, milords, one thing also, let me also say, the order is passed in 2005, and I have approached the lordship in 2013, because by order of the Honorable Bombay High Court company as milords, this company stood amalgamate to Dabur India. So after that only, and that has not been communicated, because Rule 82, the OST rule provides the order of assessment need to be communicated to us. That has not been communicated.
Communicated.
Yeah, just a minute. And the counter affidavit that has been filed, the stand taken is that the order is original having been filed, so this stand doesn't look proper, and your lordship will find annexure 3 is a certified copy. That's not the original communicated copy to the petitioner. So in view of all this, now that the matter having decided by full bench, so that may apply to this assessment. I think that will cut short the entire things.
Let's see, suppress the truth.
No, so this is the first matter, Dabur India.
It's the first matter.
What about the other?
And other matters, milords, that's very same thing. Here, milords, this entire sales, according to the milords department revenue, is sold to the alleged sister concern, which they allege, that is Balsara Hygiene Products Limited, milords. Similarly, in other two cases, so for Samsonite India is concerned, milords, the allegation is that entire milords, the goods are sold to Samtin Limited, milords.
Let's see if it is totally
just one. And so my lord is inquiry of other matters, so far similarity concerned. And so far as the automotive products private limited concern is concerned, in that case, the entire products are sold to one agglomerate. And situation is all the same. They are operating the same premises. The directors are similar in some cases. There are a number of judgments in our tribunal. I am very happy to know. Your lordship will find many judgments they refer to merely because directors common in two organizations. That will not make the other concern to be favored by or you cannot say that the transactions are collusive transactions. Honorable court has referred to all those, as well as sales officer has referred to all those, and tribunal has referred to all those, and they have passed this order based on different judgment.
Two issues. One is that against this judgment of the tribunal, has the department come in to this court, come to this court?
Now I have received the copy. Let me examine your lordship, because here your lordship.
Then that case you're taking time.
My friend has
such a scenario
before the full.
Such a scenario.
Sunil Mishra.
The petitioners have made such a scenario. Your lordship, how to defraud the revenue. Your lordship,
if you have challenged this, is different. You say Mr. Jagabandhu Sahul and senior counsel petitioner has placed before the court copy for order dated 10th March 2017, passed by the full bench of the Odisha Sales Tax Tribunal, Cuttack, in respect of the same assessee.
Same assessee. Period only.
For the period.
Immediate preceding period.
Immediately preceding period.
Yes.
1998-99. In which it was held that Section 12 bracket 8 of the Odisha Sales Tax Act 1947 bracket OST Act bracket will have no application. 12.8 is it?
Yes. Your Lordship,
Lordship,
kindly
will
quote
we
page
read
11,
12.9?
last page of the order, page 11, last paragraph. Page 11,
No,
last
12.9.
paragraph. Yes.
Your Lordship.
The ingredients of 12, section 12 bracket 9 of the OST Act has not been satisfied, and therefore the said provision could not have been invoked in the case of the said petitioner. Full stop. He submits that apart from the fact that the said judgment covers the issues raised in the present petition squarely in favor of the petitioner, he adds that to the best of the knowledge of the petitioner, the said judgment has not been challenged further by the department in this court. Paragraph. Mr. Sunil Mishra, on whom a copy of the paperwork and compilation of judgments read on has already been served by the counsel for the senior counsel for the petitioner, seeks some time for instructions. Paragraph. List on. There's an interim order?
Yes, Bills. I think I have paid the entire tax. And your Lordship said, if I succeed, then the question of interest shall be considered time of disposal of writ application. But tax is paid in full. Order dated 5/5/2016, my lord.
17th April. 17th April.
17th April. Obliged minutes.
Item 56.
My lord, 56 is covered by case of judgment, but some period is to be excluded, my lord.
Sorry?
My lord, 43 is covered, but some periods are to be excluded. South address, my lord. That will be made applicable.
Same order.
Same order, my lord. My lord, the reassessment will be made.
Here the period is 1/4/2007 to 31st March 2013.
Yes.
The 43 and 10 assessment have been concluded. But whereas the 42 assessment and 9 assessment for the period 1/4/2007 to 31st March 2008 has been completed. So that period 2007 to 2008 will be
that period needs to be reassessed.
Period.
So in that first matter, which is 8379 of 2015, same order, but concern the period up to 31st March 2009. No, the period instead of up to, concern period insofar as it concerns the period 1/4/2007 to 31st March 2009 and 1/4/2010 to 31st March 2013 is hereby set aside. Rework the demand and all that. Same order.
Your Lordship,
Second is entry tax, my lord.
set aside, but Your Lordship, it is to be restricted 1/4/2007, 31st March 2008. Your Lordship, already assessment has been completed. 42 assessment has been done. So that for that period, this case of automobile is not applicable.
Yes, 43 is to be completed in respect of 1/4/2007 to 31/3/2008. 43 is to be completed, my lord.
Petition Civil 8381 of 2015. While on account of the judgment of this court in case of automobiles, was state of Orissa, which has been affirmed by the Supreme Court and Deputy Commissioner of Sales Tax versus Mrs. Rathi Steel, the impugned assessment order for the period 1/4/2008 to 31st March 2009 and 1/4/2010 to 31st March 2013 is set aside. It is clarified that the reassessment will be completed for the period 1/4/2007 to 31st March 2008.
Yes, ma'am.
Of OET Act 9C. And under Section 10 of the OET Act, afresh, in a time-bound manner. See, while on account of the judgment in ECMAS Receipts Private Limited, State of Orissa, the assessments for the period 1/4/2007 to 31st March 2008 and 1/4/2010 to 31st March 2013 made under Section 10 of the OET Act are hereby set aside. But the reassessment proceedings for the period 1/4/2007 to 31st March 2008 under Section 10 of the OET Act will now be completed in a time-bound manner. Petition is disposed of.
Deeply ordered.
Item 57.
This is matter case. Your Lordship was pleased to admit the matter on 5/1/2016 and also pass some interim direction. But this matter is Orissa Entity Tax Act matter, my lords. The corresponding order passed under the Orissa Valuable Tax Act, similar same period of this petition has already been disposed of by Lordship, my lords. And the allegation was that they have estimated sale of chuda on the basis of one report without confrontation. And your Lordship was that set aside the matter back to the officer for re-examination. So in the light of that, this may be disposed of.
All right. You see, it is seen that as far as the demand under the Orissa Sales Tax or OVAT Act, right?
OVAT Act.
Orissa Value Added Tax Act is concerned. Bracket OVAT Act. For the period 1/4/2012, 31st March 2014,
yes,
concerning this very petitioner, this court has, by an order dated 16 March 2016, ended petition civil 22029 of 2015, bracket Mrs. Ma Annapurna Cashew Industry versus Sales Tax.
Same petitioner.
Bracket. Set aside the assessment and remanded the matter to the assessing officer for fresh decision. Stop. Paragraph. Following the above order, the impugned assessment order in the present case, which is under the OET Act, is hereby set aside, and the matter is remanded to the assessing authority, where it will now be listed on 1st March 2023. Stop. On that date, the petitioner will appear along with a downloaded copy of this order, and the assessing authority will thereafter proceed in accordance with law and dispose it of within a period of 4 months thereafter.
Deeply obliged.
Item 58.
May I please, my lords? My lord, in this case, my lord, Chapter 13 of the Income Tax Act deals with the jurisdiction of income tax authorities, my lord. Section 124 gives a very valuable vested right to the assessee to question the jurisdiction of the assessing officer in assessing his returns, my lord. My lord, overlooking this aspect, my lord, although I have questioned the jurisdiction of the assessing officer, my lord, and he was supposed to refer the matter to his higher authority. Overlooking this section, an order under Section 144 has been passed, my lord. My lord, may I take my lord to Annexure 6, my lord, at page 28.
So who's for the department?
Yes, I am appearing with the department.
Annexure 6 at page 28. This is the first time, my lord, I have received a notice. This is dated 29 December 2015, wherein I have been the notice under Section 142(1) dated 19/11/2015 has been enclosed, my lord, and I have been asked to appear before the assessing officer, my lord. My lord, under Annexure 7, my lord, at page 30, I question the jurisdiction of the assessing officer, my lord. On the ground, your lordship would see at next page 31. I'll just read out, my lord. The second paragraph onwards, that for the assessment year 2013-14, one notice has been served on the assessee, which has been received by your honor, directing the assessee to produce the documents as per notice under Section 142(1) for completion of assessment under 143(3) of the Act. That it may be respectfully submitted that neither your assessee is an assessee under your honor's jurisdiction, nor your assessee has ever filed any return before your honor. From the very beginning, your assessee was staying at Bhubaneswar and had been filing his return at Bhubaneswar, and from the assessment year 2011-12 onwards, has been filing his return at Kolkata. it will be very inconvenient for the SSC to appear before your honor at Balesur. Even your SSC does not know when the returns of the SSC were transferred to your honor's jurisdiction. Even your SSC has not been communicated about such transfer, if any done by the department. Hence, your SSC prays for transfer of his assessment records and jurisdiction to the above mentioned present address as quick as possible in the interest of justice, with the prayer to transfer it to the jurisdiction at Kolkata, my lord. My lord, overlooking this, again under Annexure 8, once again I have been issued a notice under 142(1), and thereafter, my lord, hurriedly, within just few days, the order under 144 has been passed, which my lord would find at Annexure 10.
No, but what is happening? You have an office in Calcutta.
Yes, my lord. My lord, I was an SSC since 2009 onwards. I was filing my returns at Bhubaneswar. From 2011, I shifted my base to Kolkata, and from 2011 onwards, my lord, I have been filing my returns at Kolkata. My lord, for they undertake a scrutiny assessment for the year 2013-14. Balesur, my lord, which has got no jurisdiction at all.
Sorry?
Balesur Circle, my lord, which has got no jurisdiction at all, sends me a notice under 142(1). I object in view of section 124, my lord. Your lordship would see 124 of the Income Tax Act.
Mr. Chimanka.
Yes, my lord. I filed counter, my lord.
I don't know. What do you say in your counter?
Let him appear before the assessing officer, my lord.
No, why? This is about jurisdiction, sir.
Yes, my lord.
The matter has been pending since 2016. If he is already filing returns in Calcutta, why is somebody asking him to appear before the Baleshwar officer?
And let him appear before the Calcutta office.
Oh, that he is very happy, which means the impute notices go.
I'm covered by direct judgment of Bombay High Court, my lord. I've given it to your lordship. Paragraph 7 and 9. Paragraph 8, my lord, at page 7. Page 7, paragraph 8. Learned counsel for the petitioner contends, and in our view rightly, that considering the letter and spirit of section 127, there is no reason to draw in the matter of an opportunity a distinction between an order of transfer made despite opposition of an SSC and an order not made despite his request, especially when section 124(3) has given him a right to call in the question the jurisdiction of a particular assessing officer. The total scheme relating to the jurisdiction and transfer under section 120, 24 and 127 is proportionate mix of consideration for convenience of an SSC and interest of revenue, and it aims at a striking balance between the private and public interests. The provisions of section 124 are a combination of the provisions of section 5 and 64 of the Income Tax Act 1922. Section 124 speaks of a vested right of an SSC to have his assessment made at a principal place of his business, and in case of any objection relating thereto, to have the same determined at the hands of the high authority like the commissioner. The following observation of this court in the case of Dalal so-and-so, my lord. In my opinion, section 64 was intended to ensure that as far as practicable, an SSC should be assessed locally, and the area to which the income tax officer is appointed must, so far as the exigencies of tax collections allow, bear some reasonable relation to the place where the SSC carries on his business or resides. A plain reading of section 64 shows that the same is imperative in terms. It also gives the SSC a valuable right. He is entitled to tell the taxing authorities that he shall not be called upon to attend at different places and thus upset his business. Thus, in the matter of objection to the jurisdiction of the assessing officer.
That is assessment years 2013, 14. The assessment years.
13-14, my lord. Scrutiny for 13-14.
but there are two petitions.
Two
petitions you have filed.
No, but the first petition was filed challenging the jurisdiction. During the pendency of the first writ petition, the order under section 144 was passed.
Yeah, in challenge. As much as the order concern income tax circular.
Complying with section 124, bracket 4 of the Act. Paragraph. The background facts are that the petitioner initially carried on his business activities from Bhubaneswar in Orissa. And was filing returns there. Full stop. For the years, assessment years 2006-7, 7, 8, and 9, 10. Assessment orders under section 143, bracket 3 of the Act were passed by the AO at Bhubaneswar. Paragraph. Appeals had also been filed against those assessment orders before the Commissioner of Income Tax, bracket appeals -1 Bhubaneswar. And thereafter, no, Bhubaneswar. Full stop. However, surprisingly, pursuant to the said order passed in by the CIT A Bhubaneswar, an order on 31st March 2015 under section 251 of the Income Tax Act was issued by the ACIT Baleshwar Circle, Baleshwar. Paragraph. The petitioner was surprised that the jurisdiction had been shifted from Bhubaneswar to Baleshwar. And he accordingly filed an objection on 10th March 2016. So in this letter, he mentioned that from the beginning, he had been filing his returns at Bhubaneswar. And since AY 2011-12, he had been filing returns at Kolkata. So he was unaware when the jurisdiction was transferred to Baleshwar. So he accordingly prayed that the assessment records should be transferred to Kolkata. Stop. However, on 8 March 2016, the ACIT Baleshwar again issued notice to the petitioner under section 142, bracket 1 of the Act, requiring his presence on 29th March 2016 in connection with the returns filed by him for AY 2013-14. Stop. Along with this notice, a notice under section 274 read with section 271 of the Act was also issued, was also enclosed. Alleging violation. Alleging non-compliance with the earlier notices and proposing penalties under section 271, bracket 1, bracket small b of the Act. Paragraph. Writ petition civil 5586 of 2016 was filed by the petitioner at that stage, stating that, containing that under section 124, bracket 2 of the Act, the matter had to be referred to the competent authority for determining the jurisdiction, and without such order, the ITO, the ACIT at Baleshwar could not have simply proceeded to issue notices to the petitioner. Full stop. In this petition, a direction was issued to the department by this court on 13 May 2016 to obtain the assessment records. Full stop. Paragraph. When a further notice was issued by the ACIT Baleshwar on 29 March 2016, along with the demand notice of the same date, the second writ petition 7861 of 2016 was filed with the petitioner, in which an interim order was passed, staying the said notice and demand and consequential demand notice. Full stop. Paragraph. In the counter affidavit filed on behalf of the department, in writ petition civil 7861 of 2016, it is sought to be contended in para 6 as under. Stop. Reproduce para 6, pages 46 and 47 of writ petition civil 7861. Paragraph. Fact remains that merely because the petitioner happens to be a director of Messrs. Nabadurga Minerals, Rairanpur Mayurbanj, which is being assessed in the Baleshwar Circle, would not automatically transfer the jurisdiction as far as petitioner is concerned from Kolkata to Baleshwar. But you had to inform, no? Suppose you had moved to Calcutta, are you not supposed to inform your ITO in Bhubaneswar that you moved to Calcutta?
I'm not sure, my lord.
I think you have to.
But over here, my lord, there is a violation of 124, my lord.
All right.
Over here, once I've raised an objection.
What the counter affidavit, however, does not answer is how this transfer of jurisdiction could take place without complying with the mandatory requirement of section 124 bracket 3 of the Act. Full stop. In this connection, the following observations of the Bombay High Court in the decision in Devidas versus Union of India, 1993-2001, 200 ITR 697 bracket BOM bracket are relevant. Take A to A. With that being no reply to, no convincing answer given by the department to the shifting of jurisdiction, first from Bhubaneswar to Baleshwar and then Baleshwar First, shifting of jurisdiction to the Baleshwar circle, when admittedly the petitioner has already shifted to Calcutta and has been filing returns there. The court washes the imbue notices issued by the ACIT Baleshwar to the petitioner.
Annexure 10, man.
Yes. Packet Annexure 10 series in writ petition civil 7861 of 2016. Paragraph. It is clarified that the petitioner will continue to be within the jurisdiction of the relevant income tax circle at Calcutta, where he has been filing his returns. To stop, this order will not preclude the department from proceeding the courses of law if it proposes to transfer the jurisdiction of the petitioner to any other circle.
Grateful, man.
The petitions are disposed of in the matters.
Item 59.
Your Lordship, I'm sorry, Your Lordship. Can I pray small adjournment, Your Lordship? This past file is somehow missing, Your Lordship. The with file is with me, but the past
At the
file.
request of counsel for the department. List on 17th August.
The interim orders in both cases.
Interim order to continue.
Your Lordship.
Both the cases.
Right.
Item 60.
Item 60, it's a matter under CST Act, provisional assessment for non-submission of C forms. Lordship, in a recent order, even a copy to relegated the party to the appeal.
Your Lordship has relegated to for filing of appeal only pre-deposit, Your Lordship, after.
Paragraph 5.
Say, following the judgment order that dated 16 January 2023 of this court, in writ petition civil 17460 of 2020, bracket Messrs. Saurav Alloys and Steel Private Limited, then Canal versus STO, then Canal Circle. This court issues the following directions. 5 and 6 will reproduce.
5 and 6.
Yeah, reproduce 5 and 6.
Deeply.
All matters.
Item 61.
May I please, my lord?
Yes,
May I please, my lord? My lord, this is with respect to this export obligation fulfillment, whether INR could be calculated towards fulfillment of export obligation, my lord. Now, my lord, there is a policy relaxation which is there in my case, my lord, which I have enacted, my lord. There are also appendix 5D of the foreign trade policy, which remains unamended, my lord. My lord, having said that, my lord, what I understand is that the counter has not yet been filed, my lord.
No, it has.
My lord, respondent 1 has not filed the counter.
One has not filed. 2 has.
One has not filed the counter, my lord. On the last occasion, the lordship has said that, it will be like a last opportunity to them, my lord. My lord, if they want to continue without the counter, my lord, let them put that on statement, my lord. And next week or something, my lord, it may be kept, my lord.
Yes, who's for one? Mr. Padi or?
Yes, Mr. Padi.
Anyone appearing for Mr. Padi? Were they appearing previously? No, I don't think Mr. Padi has been appearing. First hearing he did. It is seen that Mr. P.K. Padi Leonard, DSGI, had appeared in this petition on 15 February 2022. While notice was issued, full stop, however, while opposite party number 2 has filed a counter affidavit, opposite party 1 has yet to file a counter affidavit. Paragraph today, none is appearing on its behalf. So the last opportunity is granted the Union of India in the Ministry of Finance, Department of Revenue, to file its reply on or before 3rd April 2023. Rejoined to the said counter affidavit as well as the reply of opposite party number 1 be filed with the petitioner before the next date. Paragraph. Interim order to continue. List on. April 24th. Interim order. Yeah. Yes. All right.
Item 67.
May I please your lordship. The petitioner challenges the order of under annexure 1 of the attachment of his bank account, my lord. Well, I may be permitted to place paragraph 4, 5 and 6, madam.
2 weeks more time may be required for filing of counter, your lordship.
So the bank account is attached, you keep taking time. What's the balance in the account, sir?
My balance is very low, my lord.
Low. So it doesn't bother you then. Counsel for the department seeks and is granted last opportunity to file reply within 8 weeks, adjourned for the next stage. Let's answer this. 21st August.
Item 69.
Sorted maybe.
It's all right. Doesn't matter. Nothing, no amount in your account. Yes.
Item 69.
Lord, it's a on-shop.
Now in fractures.
In fact, I have a small cause of action, but small. Since 8 and 9 shop was licensed, it's an on-shop part of a hotel. So it can't be segregated. Now, suddenly 8, 9, I have been operating. But at the behest of the rival traders, the ward members, they suddenly objected, selected this out of many other shops. Now, superintendent passing an order that commissioner has directed you to shift. Now, shift it within a stipulated period. It can't be segregated. As I say, it's a part of hotel. It's not a restaurant or a on-shop. It can't be segregated. So today, there is also no objection because all those shop owners, those who are in fact indirectly objecting, they have lost their license in the last lot. So that kind of opposition also are not now before me. But all that I need is not shop is operating. So till a fresh cause of action arises, let the interim order continue, let them consider if the cause of action arises, that will be seen.
There is an interim order of status quo, so he is operating. Now, your lordship may direct the commissioner to re-examine the matter.
All right. The petitioner's on-shop was sought to be, the petitioner's on-shop, which is located within a hotel, was sought to be closed down by means of the order passed on 13th August 2014 by the Superintendent of Excise, Khurda. And he was asked to shift to an alternative unobjectionable site. Full stop. Paragraph. At that stage, the petitioner approached this court, and on 5th September 2014, an interim order was passed, permitting the petitioner on shop to function at the present location until further orders. Stop. That interim orders continue till date. Paragraph. Meanwhile, the parties at whose behest the impugned order was passed have themselves ceased to be license holders in the area. Full stop. With the interim order having continued and with the above changed scenario, the court directs that the petitioner will continue to operate at the existing location till such time any proceedings, any further orders are passed in accordance with law by the authorities.
That will end the matter. Grateful.
The petition is disposed of in the above case.
Item 70.
Kindly pass over.
Pass over. Pass over.
Item 71.
Item 71, my lord. Here is a demand on the basis of the AG report for short yield of the rectified spirit, my lord. Can you have a glance to annexure 3, page 24.
The next page, 25 page is the brief, my lord. Second paragraph, may I place it, my lord?
Yes,
Second
please.
paragraph.
Yes.
The test check of stock of taking is the report of the Umeri Distillery Private Limited for the year 2009-10 to 13-14. During the audit reveals that the distillery sent molasses for a chemical examination twice a year for the above years. But during the 2009-10 and 11-12, the average probable, my lord. So what they have used, probable outturn of alcohol per MT of molasses was shown as 201.97 BL and 214.1625 BL in the sample test of molasses. The unit utilized 5306.15 MT of molasses during the above 2 years, and the probable outturn of the spirit was calculated to this much.
But
But the unit is-
basically they've said there's a short yield, and you should pay duty on the short yield.
Yes, my lord. Short yield. My lord, they cannot say that this much of molasses could produce this much of spirit. That cannot be, my lord. That is the case, my lord.
Was it based on any scientific study or just like that?
Counter affidavit is filed by the superintendent.
What does he say in that?
Para 9. Non-levy of excise duty on excess wastage of spirit amounting to rupees 80. In this connection, it is submitted that the distillers have submitted an affidavit that they will pay the demanded amount of rupees so and so by 4-5 installment during the financial year. So there was an undertaking that they will.
That is different. What you're now trying to say is you have paid excise duty on X amount.
Yes.
You should have paid it on some X plus amount. That X amount is a short yield.
Yes, madam.
Where do you get? There must be some basis for determining that.
That the audit party has objected and they found this. So in the
page 26, my lord, they said it is probable, my lord.
That's right.
Lordship may direct the government to take a decision because in all AG audit reports, the Lordship is normally passing the order that the government is to.
It cannot be, my lord. It is probable that they cannot.
Probable means there must be some materials. Otherwise, the counter.
But even the counter, same words just repeated.
Probable.
That way, fortunately, you've not tried to improve the reasons in your counter affidavit.
No,
you're just repeating
what is there in the letter that has to be stated in the counter.
I know.
We cannot.
So there's no other means of finding out what led to your decision.
This is a demand of more than 10 lakhs rupees, my lords. So let the government take a decision on this. Your lordship.
Now, see, this is a manufacture of alcohol that took place in 2000.
9, 10 and 11, 12.
9, 10, 11, 12. Where are you going to find materials to show whether it's short yield or not?
No. So far as this probability is concerned, how the authority is justifying it and how there is the ground is that they have admitted that we will pay this amount. That
not
is also
on this. No, sorry, not on this. This is some.
No. There's a general statement made by them that we'll pay in installments whenever you raise a demand. That had nothing to do with the short yield part.
Recording that observation, your lordship may remit back to.
Why remit back? We have to bring some things to a close. This is all pending since 6-7 years now. All right. The petitioner who runs a distillery in which alcohol is produced from molasses. At a factory owned by the petitioner. No, at a factory in Jaipur, district Koraput, has filed this petition. Questioning demand notices issued on 27th June 2015 by the Superintendent of Excise, Koraput, requiring the petitioner to pay rupees 10.4 lakhs on alleged single quotes short yield of rectified spirit, unquote, for the year 2009-10 2013-14. Full stop. Also challenged is another letter dated 21st March 2016, issued by the Excise Commissioner to the Superintendent of Excise, Koraput, requiring it to furnish a compliance report in respect of the aforementioned non-realization of excise duty on the short yield of spirit, as was mentioned in the report of the Comptroller and Auditor General, bracket CAG, bracket, for the year 2014-15. Paragraph. So while issuing notice in the present petition on 20th May 2016, this court there was no interim order, Mr.
No, my lord, there is no interim order.
Asha, notice was issued in the present petition on 20th May 2016. What happened? You paid the amount?
Yes, we have later on we have paid because to continue with our license.
Mr. Guru, learned counsel appearing for the petitioner, informs the court that in the meanwhile, the impugned demand amount has been paid by the petitioner, since it did not want to discontinue the production at its factory. Paragraph. A perusal of the impugned demand notice reveals that it was based on a draft note received from the Deputy Accountant General, Bhubaneswar, about alleged irregularities having been pointed out by the audit during test check of stock taking at the petitioner's unit for the aforementioned years 2009-10 and 2013-14. The exact paragraph which formed the basis of the demand, exact paragraph in the report, audit report, which forms the basis of the demand, reads as under page 25, take from page 25, second paragraph, test check of stock taking till annexure. Paragraph. The counter affidavit filed on behalf of the opposite parties does not throw any more light on the reasons that weighed with the excise department in raising the above demand. Full stop. The wording of the above paragraph is repeated verbatim, and it is stated that there was a open quotation that the open quotation average probable outturn of alcohol per MT of molasses was shown as 201.97 and 214.1625 bulk liters in the sample test of molasses. Stop. In other words, the shortage, supposed shortage in the yield of spirit from the molasses was based on probability and not any actual scientific study. Full stop. In short, the shortage in the yield was based on surmises. Full stop. The duty itself has been calculated on the above basis. Paragraph. This is apart from the fact that no show cause notice was issued to the petitioner before concluding that there was a short yield, and no explanation was called for from it as to not adhering to the prescribed yardstick for wastage of spirit. That is 1.5% as per the board's excise rules 16(2). Paragraph. For the aforementioned reasons, the court finds the impugned demand raised on the petitioner by the notice dated 27 June 2015, followed by the letter dated 21st March 2016 of the Excise Commissioner to the Superintendent of Excise, Koraput, to be unsustainable in law, and both are hereby set aside. Paragraph. With the petitioner having already paid the aforementioned sum of ₹10.4 lakhs, it will be open to the petitioner to seek its refund in accordance with law. The writ petition is disposed of in the publics.
Item 72.
72 permitted to withdraw, Your Lordship.
Dismiss is withdrawn. All right.
Item 73.
That is also infructuous.
Dismissed as infructuous.
Item 74.
Lordship,
Item
none appears for
74,
the
Your Lordship
73 say none appears for the petitioner. Counsel of the opposite party states that the petitioner is in any event been rendered in fact. It is dismissed as such.
Item 74.
In item 74, Your Lordship would kindly take the last order dated 11/2/2021, my lords. The larger issue was pending before the Honorable Supreme Court. Your Lordships had directed liberty was granted to the parties to mention for listing after the disposal of the SLP, my lords. The current status, I'm just I'm forwarding it to Your Lordships, my lords. It is still pending, my lords.
I see.
We have gathered our instructions. It is still pending.
All right.
Just pass on.
It is stated that the matter in the Supreme Court is still pending. List on 4th September.
Millards, the last two, the sub-item in the sub-item Millards, it is along with WP 12115 and 12119 Millards. These two applications have to be de-linked, Millards. It has got nothing to do. It was under the SVL DRS, Millards. It has already been disposed. It's got nothing to do with the main case which is pending for constitutional penalty. This may be detagged.
That 1795 one itself?
No, 1794.
The records of writ petition civil 12115 and 12119 of 2019 need not be
Millards
placed with these matters.
Millards. There was an interim order, Millards, that may please to continue.
Interim order to continue.
Deeply obliged.
Item 75.
Mr. Patra's case, all the cases are being passed over. But so far as this case is concerned, Lordship may not pass over it. It may be taken up any other date because there is a full-fledged hearing has to be taken place.
But I'll request Your Lordship, since the license will be due for renewal 31st of March, sometime during first week of March, Milord, can be
that
done.
And he has also not filed any counter. The private
not required also.
File କରିବନି ହେଇଛି ଠିକ ଅଛି. The pleadings are complete.
Rejoinder is a very formal issue. It's necessary. Sometime first week of March, my lord. Without, if it is not inconvenient to my lord, or second week, as Your Lordship pleases.
I can take a chance on 2nd March.
2nd March. Great.
Item 76.
Item 76 concerns a matter of rent control
this act was repealed in the year 1988. I am supplying the act so that it can be. Under this particular act, the petitioner claims to be the owner of the land, and he filed an application under section 7 to evict the tenants. The section 7 may kindly be perused. It says there are many conditions. Rent is, if the rent is not paid, the another important condition is section 7 subclause 2 Roman 4. It says that the tenant has denied the title of the landlord or claimed that a right of permanent tenancy, and that such denial or claim is not bona fide. This was the issue also before the landed.
That act is repealed.
Yes, 1988.
So, why?
Now this act when it was this case was filed, it was not before the repeal. The matter carried on. The repealing act also says that which the matters which were pending will continue as such, and there is also a judgment of this honorable court. If you are, I will come to it, my lord. Now what happened? The matter, the tribunal allowed my application and said that there must be an eviction. Now the tenant went for appeal.
Who is your contesting respondent now?
Your Lordship, in this case, I am for the respondent. The other respondents are already there, but they are not appeared. But today, my lord, a wrong file has come. I pray, my lord, day after tomorrow, on Friday.
There's an intermod in your favor.
No entry, madam.
No, there's no intermod. You're right. What is this, residential or non-residential?
I beg your pardon, my lord.
Premises is residential or non-residential?
This is a commercial. This is
commercial.
Mill. This is a mill.
Non-residential.
Rice mill.
All right. You're the landlord.
Yes, my lord.
Counsel for appearing for the respondent tenant states that she's in some personal difficulty today. List on. Is a writ appeal maintainable, sir? It's a 227 jurisdiction, single judge?
Yes, my lord, that is there. But
how is a writ appeal maintainable?
My lord, so far as this tribunal is concerned, I went through this particular act. I believe that the trappings of civil courts.
No. Against the rent control tribunal.
Yes.
This HRC appeal, already there's an appeal.
Yes.
Against which you've come in writ petition.
They came.
No, they came 227.
Yes.
So against 227, how is the writ appeal maintained?
It was the nomenclature was in 226 and 227. I understood your lordship's question, my lord. That's 2015 judgment of the annual apex court.
You say in the next state, the
I will satisfy.
The petitioner will satisfy the court that the present writ appeal is in fact maintainable.
Yes.
List on. 17th August. Please.
Pass over item number 42.
Sahu, Mr. Patro is here. He was mentioning for us.
There his colleague is here.
42 after lunch.
After lunch, kindly.
After lunch.
He has two cases, 42 and 70.
All right.
After lunch, 42 and 70.
All right. 42 and 70 after lunch. Weekly list.
In this next list, item 76 is a 74 is a covered matter.
Narottam Ratha. Narottam Ratha.
Yes, ma'am.
74.
74.
74 covered.
There are three cases there. In 74.
Also item 57. Same
57 and 74. All these slips. So you call out one by one, you can call it. That all those slips you first call out. This is the Narottam Ratha matters. Just call it out.
Weekly list, item number.
No, you call out from this.
Weekly list, item number 13.
Yeah, Narottam Ratha. Oh, withdrawal, dismisses withdrawal, sorry.
Item number 26.
Withdrawal, dismisses withdrawal. मैं मुंह छोड़ने देता हूँ.
Item number 39.
Withdrawal.
Item number 87.
Withdrawal.
Item number 89.
Withdrawal.
Item number 122.
Withdrawal.
Item number 57.
Narottam.
This is Narottam. That there are
Item number 74.
Yes, ma'am.
All right. All right.
Said item number 49, 50 and 51. Also Narottam.
How? 49?
49, 50 and 51.
Ah.
I am appearing for the 49 lots, one transfer.
It is entering appearance.
49, 50, 51.
Just ask somebody to collect that.
Item number 49,
50 and 51.
Item number 49, 50 and 51. Weekly list. Item number 2.
My lord, in this case, I have no power, my lord. After the death of sole petitioner, my lord, I have been instructed by the legal heirs of the sole petitioner to appear on behalf of them, my lord. I have sent my Bhakalarnama. I have not obtained till date, my lord. So it is 3 weeks time, my lord.
What's the matter about, sir?
Matter, my lord, the ADM Bhubaneswar has rejected the claim of the petitioner under OGLS Act. And the claim of the petitioner that has been, the land has been granted under the scheme implemented by the state government, which is not coming under the OGLS Act, but to the defense personals, there was a scheme. After rendering 5-year service, under Annex 2, there is a scheme implemented by the state, my lord, to provide land, 5 acres of land. But the state claim has been rejected under OGLS Act.
What do they see in the counter?
Counter, my lord, my result submission, I have not appeared, so I have not gone through the counter, my lord.
No, but based on this case, you got it. The allotment.
Paragraph 15 of my counter may be seen, page 5. My lord. The concession of land in favor. This is a Javan lease, 2014, that was above my lords. This petition, my lords, has been filed by the power of attorney holder. The petitioner has filed it on behalf of power of attorney holder. Now today, my lords.
No, are they subsequent purchasers? Are you subsequent purchasers? You are the original lessee.
Land has been granted for the petitioner.
The original lessee is appearing through his power of attorney holder. Now, my lords, today, the original lessee, as I understand, is no more. My lords. So the power of attorney also goes. So therefore, my lords, today, my lords,
so
the other side, my lords, how can they appear? My lords? There is no one to appear.
No, how?
How will they substitute?
Sorry, my lord. Earlier I was counsel, sole petitioner died. Earlier a cousin. Therefore, my learning senior is today appearing.
That sole petitioner was himself a power of attorney holder.
Yes, your lordship.
No. So what happened to the original lessee?
Original petitioner died. Then his power of attorney ceases. Therefore, their legal heirs needs to be, my lord, substituted.
When did he die?
Your lordship.
On 12/4/2022, my lord.
Then my lord senior is appearing. Then I have no instruction in this matter today, my lord.
And also, out of 5 acres, the power of attorney holder had for 2 acres. So for 3, and in those 2 acres, he has been siphoning off the selling the land, and under the Jawan lease case, the land is given for farming, my lords. And the Tahsildar report and everything shows that he's been selling it off as a real estate agent. my lords.
No, but he says his short point is this was granted under the Government Grants Act and not under the OGLS Act.
Because even if under the government's grants act, my lords, that because he was a ex-serviceman, so therefore, my lords, that particular land was granted for farming. And what was found that my lords, we have said in para 15 at page 5, my lords.
No, if you admit that it was granted under the OGLS Act, because I thought your case, the counter is it was granted by an order passed in a WL case.
Yes, my
under
lords.
the OGLS Act.
My lords, even if I take for a moment that his argument that it was granted under the Government Lease Act, still, my lords, it was for farming, my lords. Both counts, my lords, he falls, my lords.
No. But the proceedings for evicting him can't be under the OGLS Act then.
My lords, may take it up after lunch, my lords. I'll again go.
Because earlier they had filed OJC 17107.
That's right.
And this was sent back to the ADM to determine whether in fact the OGLS Act applies.
Applies.
Somewhere the order acknowledges that it was granted only the government grant.
My lords, may see my a date chart has been given, annexure A by 2, my lords.
Bottom of page 18.
Yes.
Annexure 1. And
Right.
the government have clarified in 1986 that the thing that the government land was made under government grants act. And the Tahsildar has settled the.
Please, my lords.
That is a government land act regulation.
Please.
Collector exercise.
Under the OGLS Act, my lords. I appreciate that. I may take it up post lunch, my lords. I'll satisfy.
Or it will stay on hold. Do it next. File your application email.
None. Item 3.
Your Lordship, in item 3, I'm grateful on Thursday, Your Lordship allowed me 2 days time to file my counter. I've made the counter affidavit and list of dates. I've served my learned senior over internet also.
My lord, I may be allowed to file a rejoinder to this counter affidavit because this is necessary for the reason that new facts have come up now.
Hand over in court. The counter affidavit along with the list of dates. Copies of which have been served in list in the regular list on.
Lordship, just one thing. There is a similar matter posted by Your Lordship on 10th of August. That is writ petition number 6395 of 2014.
List along with 6395 2014 on 10th August. Interim order to continue. Right.
We are grateful.
In the regular list.
Obligation.
Item 4.
Non-obvious dismissed. And for the opposition.
Item 5.
Non-obvious for the petition dismissed.
Item 6.
Your Lordship has passed over item 5. No, dismiss for non-prosecution.
Item 7.
No. Item 6 is that.
Item 6.
Lordship, item
Sorry.
6, I want to draw your Lordship's attention, only 3 orders, Lordship. And Lordship kindly come to page 39 in pursuance to Lordship's order. And all of this is statutory obligations, Lordship. Lordship kindly stated, come to page 43, concluding part, Lordship, page 43. Lordship, page 43, just I'm reading Lordship's second paragraph. It is a fact that no complaint has been received from any laborer at our end against the contractor for non-payment of enhanced minimum wages, nor any case was filed by the laborer in the labor court. Therefore, it may be considered to implement the order of passed by Honorable High Court to reimburse rupees 16,36,285 rupees towards enhanced labor wages to Messrs. Construction without any further delay. The claim of the contractor for payment of the interest on the above amount may not be accepted as the order of Honorable High Court only speaks about payment of enhanced minimum wages. This is the order of the state government, Lordship, in personal Lordship's direction. Then Lordship kindly come to Annexure 2, page 45. Again, Lordship, on 6, 7, 12, they come up with another figure with a proper calculations, Lordship. In inviting a kind reference to the above cited letters and subject, it is stated that as per discussion held with you in our office chamber, such and such, the senior DO of the office has checked the labor escalation bill of Messrs. Construction, and the total amount calculated by him comes to rupees 12,31,438 rupees. They reduced, Lordship, 4 lakhs. Instead of against claim of agency for rupees 16,30,000. This is the calculation of their own officer, Lordship. Then Lordship can, and then followed by the entire calculation. Then Lordship kindly come to page 51, Annexure 4. Again, in my absence, Lordship, in my presence or without any knowledge, they have reduced another 5 lakhs, Lordship, kindly see. In inviting reference to subject side above, it is to inform that an amount of rupees 7,20,359 only has been approved by the Department of Water Resources Odisha for release of labor rate and disbursement to the agency subject to verification of payment of enhanced rate before release to agency. Therefore, you are requested to submit the proof of payment, and this amount they have already paid, Lordship. These 7 lakhs they have paid, but my humble grievance before Lordship is they have reduced from 16 lakhs to 12 lakhs, now it is 7 lakhs. Only a Lordship, let them reconsider Lordship because it is without my knowledge. They have considered persons Lordship direction to, then they come to a conclusion that 16 lakhs odd amount is liable to, they are liable to pay Lordship. Then it is 2 lakhs, now it is 7 lakhs Lordship without my.
Before my lords is a contractor, my lords. This is pursuant to a contract. There are contractual.
Civil remedies.
Civil remedies.
It is minimum wages Lordship. Minimum wages is statutory obligation. It is not Lordship contractual. This is.
But that involved dispute questions.
No, Lordship. They are admitted. That I am not saying any amount, Lordship. That is their calculation. Lordship, kindly see page 43. That is their calculation. Persons Lordship's direction. Page 43. Lordship, come to page 43. Because they have gone up to Supreme Court Lordship and they lost the case, and this is the outcome of the order of this annual court Lordship. And the Lordship gave a direction, and Lordship page 43 para 2. This is the report of the additional secretary of the state government Lordship. They have come to conclusion that rupees 16,36,000 Lordship, kind of the language Lordship. It is a fact that no complaint has been received from a labor at our end against the contractor for non-payment of enhanced minimum wages. No, nor any case has been filed labor in the labor court. Therefore, it may be considered to implement the order passed by Honorable High Court to reimburse rupees 16,36,000. That is their own admission Lordship. And it is personal Lordship's direction.
My lords, may see a counter, my lords. If my lords, the first objection, my lords, second on merits, my lords. My lords, page 6, para 12, my lords. That's
yes,
6th line, my lords. It starts with at first. At first, that is before the interference of the Honorable Court, the contractor petitioner had submitted a price variation adjustment bill for labor component amounting to rupees 10 lakhs. After judgment of the Honorable Court, the petitioner submitted another price escalation bill amounting to 16 lakhs for payment. Since the Honorable High Court had passed the order to reimburse the enhanced rate of wages of labor component paid by the petitioner, the works department, with best of intention, asked the petitioner to submit the relevant records or documents in support of payment of enhanced labor rates to the laborers. But the contractor petitioner failed to submit the same. In the meantime, the executive engineer assessed the escalation bill for so-and-so. As the same was not based on actual item-wise labor component, the executive engineer again reassessed the amount, which is 7,20,000. So, certain documents were asked for him because unless he has paid the enhanced rate, has passed on to the laborers, my lords. So, to satisfy, my lords, that particular aspect, my lords, he was asked for certain documents. Till today, my lords, let my friend clarify if he's given those documents to the department, my lords.
Lordship, kindly page 42 for us, my lord, have not gone through the records, Lordship. Page 42. That is all been dealt with. That was the subject matter, Lord, before the additional secretary also. Because Lordship can see page 42, I'm reading, Lord. Accordingly, Lordship, page 42 note sheet. Accordingly, executive engineer Chikiti Irrigation Division was instructed by letter number such to verify the detailed wages paid to the laborers individually before releasing the amount towards enhanced rate of wages to laborers in favor of Messrs. Construction. The executive engineer was to satisfy himself that the contractor had actually paid the enhanced rate minimum wages to the laborers.
For which you have to submit documents.
Already have submitted, Lordship. After considered submission, this is the order passed by the additional secretary, Lordship. Lordship, page 42, entire thing is dealt with by the additional secretary. And after considering all those allegations, additional secretary come to a conclusion, please release 16,36,000. And after this order also, Lordship, this executive came with the second figure, Lordship, annex 2, they reduced it to 12 lakhs. Now, my humble submission, I have no grievance if they are passing the order in my presence. With these two orders by additional secretary and the executive, they have ignored. Now they have come with a new figure before this honorable court, that is 7 lakhs. So, Lordship, let it be heard, let it be considered, because I have produced all the documents. And Lordship, kindly see my rejoinder. I have produced the documents.
No, this becomes like a trial then.
Yes, sir.
Lordship?
Becomes like a trial.
Please.
Because you will have to support, produce a document which shows proof of your having.
Already filed, Lordship, already filed and they have considered. Lordship, can you notice the additional secretary? This was the submission of executive engineer, and for that reason, Lordship can page 43 as a whole. That no labor has made any complaint. He has given no case is pending against him. He has given the escalation pitch. That's why this additional secretary come to a conclusion. He released 16 lakhs. Now, my lord, after belated stage case of 2007, Lordship, contract of 2007, in 2022, Lordship, can they claim the master roll or any documents, Lordship? When the documents itself, the contract itself, the agreement speaks, the document has to be preserved only for 1 year. That is their document.
On what basis was he told that 16 lakhs is payable to him? Obviously, this entire exercise must have done before that letter was written.
Please, Millards. Therefore, Millards, because we didn't have the itemized.
No, but you arrived at a figure.
Yes, Millards, we have arrived at a figure.
How did you arrive at without all this?
As for that, we'll have to see the records, Millards, and precisely what Millards was saying that
if
this
you had
is
said approximately and then
civil
subject to verification, I can understand. You give a very precise figure.
Please, Millards, and hence he was.
And then
asked,
without notice to him, without hearing him, you just change the figure.
in that case, let him go before the authorities and. Because he's ultimately he's also disputing the figures. It's not like he's not disputing.
If you're willing to reconsider, there's no need for him to come to you. You reconsider anyway.
But the reconsideration will again be subject to the documents that he has to supply.
This is the whole thing. You're making him run around circles after 7 years, 8 years, 9 years. Nobody preserves documents like this endlessly. You carried out the contract when in 2008.
This was
Sidalai.
Lordship, 2007 contract, Lordship.
How is he supposed to preserve these documents?
The conditions fixed for 1 year, Lordship. Page 100, that agreement says, Lordship, we have to preserve the documents only for 1 year. That agreement says, Lordship.
But the note sheet is 2013, and my friend said that
then we are
given,
2023.
Therefore,
what do you do?
Lordship,
You're a contractor.
Contractor, Lordship. And we have already paid, Lordship. That's the whole. Because it cannot be, Lordship, escaped, Lordship, because higher wages has to be paid. In front of the practical, Lordship, we are giving more fees, Lordship. More than government amount, Lordship. When the government is 200, Lordship, we are giving more than 500, Lordship. That is their, Lordship.
And the period in the present petition was for quashing an order dated 5th January 2015, passed by the executive engineer, Hikiti Irrigation Division, Berhampur, Ganjam, stating that a sum of rupees 723,559 has been approved by the Department of Water Resources, Orissa, in favor of the petitioner, open quotation, for release of labor rate and disbursement, unquote, comma, subject to verification of payment of enhanced rate before release to the agency, full stop, unquote. The grievance of the petitioner is that the work entrusted to the petitioner for renovation of the left main canal of the Bahuda irrigation project in the year 2006, comma, with the stipulated date of completion as 25/1/2007, could not be completed due to various reasons. Full stop. The first application for extension was 5th June 2006. And the second extension applied for was from 31st March 2009 to 25th May 2009. Full stop. Paragraph. The case of the petitioner is, while making payment to the petitioner, the opposite parties did not provide for increase in the minimum wages of labor, which had been ordered by government notification dated 28 April 2007. Full stop. The petitioner refers to notifications and guidelines issued by the state government, which state that the state shall pay the differential amount of minimum wages at the time of paying the final bill. Full stop. In the present case, according to the petitioner, while paying the final bill in December 2009, the differential cost for increase in minimum wages was not paid by the state. Full stop. Ultimately, by letters dated 21st March and 11th April 2011, the state government rejected the claim of the petitioner for the differential amount towards increase in minimum wages. Paragraph. Initially, the petitioner filed writ petition civil 19008 of 2011 in this court. So the said petition was disposed of on 16th May 2012. Following an order dated 19th September 2011 in writ petition civil 2114 of 2010. Full stop. Operative portion of the said order reads as under. Take internal page, para 13, sorry. The quoted portion, para 13 of the writ petition, pages 8 and 9. The SLP against the said order by the state government was dismissed by the Supreme Court of India on 18th April 2013. Paragraph. The petitioner then again approached the authorities regarding implementation of the court's orders. Paragraph. On 6th August 2012, the executive engineer Chikiti irrigation project wrote to the chief engineer with specific reference to the claim of the petitioner for reimbursement of the enhanced rate of wages. Stop. The said letter reads as under. Take from page 45 the word sir in the last paragraph. On the above basis, it is contended by the petitioner that the opposite parties had already determined the amount that became payable to the petitioner. In the orders passed in contempt petition, filed by the present petitioner, a submission was made on behalf of the state that the admitted dues of the petitioner to the tune of rupees 12,31,432 quote had been recommended by the EE And then the matter was with the higher authorities. It's up on 11th December 2014, the division bench hearing the contempt petition directed the opposite party state to release the amount involved in favor of the petitioner and file a complaints report. It is thereafter that the impugned letters were issued, recalculating the amount due to the petitioner as ₹723,359 and releasing that amount. Full stop. Paragraph. The petitioner's grievance, therefore, is that as against the sum found payable to him, that is ₹1636,285, he was paid only ₹720,359. And this was unilaterally done by the opposite parties without even notice to him or giving him a hearing. Full stop. The petitioner then made a grievance to the opposite parties. And in dealing with it by order dated 27 July 2013, the additional secretary in the government observed that with the SLP against the order passed by this court having been dismissed by the Supreme Court of India, the orders, open quotation, the orders of the High Court shall be implemented and the bill of the petitioner towards labor component as per the enhanced rate fixed by the government needs to be reimbursed. Full stop, unquote. Paragraph. Paragraph. While the EE requested the petitioner to furnish the muster roll and other documents in response to the petitioner's representation dated 15/10/2013, the additional secretary opined as follows. Take from bottom of page 17, top of page 18, the entire paragraph. When, despite the above letter, no further amount was released beyond ₹720,359, the petitioner filed a present petition, praying for directions to the state to pay the differential amount without delay. Paragraph. Pursuant to the notice issued in the present petition on 3rd November 2015, state has filed a counter affidavit in which it is sought to be contended that because the petitioner had not submitted the relevant records documents in support of payment of enhanced labor rate to the workers, he was not paid the entire sum determined to be paid earlier, that is ₹1636,285. It is now stated that the assessment by the EE of the amount of the escalation bill being payable to the extent of ₹1231,432, open quotation, was not based on the actual item-wise labor component, unquote. Full stop. It is thereafter that the EE, open quotation, again reassess the amount basing on the actual item-wise labor component derived in the original estimate, taking from the single quotes analysis of rates, unquote, approved and published by the government of Orissa, with that of the quantities executed after enhancement of the minimum wages labor. That is 1/5/2007 to 31/3/2009. Stop and quote. Paragraph. Having heard learned counsel parties, the court is of the view that the above stand taken in the counter affidavit is unacceptable for the simple reason that the reworking of the amount due to the petitioner was led to some getting drastically, some payable to him getting drastically reduced from rupees 1636,285 to just rupees 723,359. Full stop. Paragraph. Even the counter affidavit does not explain the basis on which there could be such a huge reduction in the amount payable. Full stop. It is inconceivable that the earlier determination of the amount payable at rupees 1636,285 was done without properly examining all the documents submitted by the petitioner. Paragraph. Mr. Mohanty, learned ASC for the state, suggested that the petitioner should again be asked to submit all the documents for the state authorities to examine and again determine what is payable to the petitioner. Paragraph. The contract having been executed way back in 2007. And with the present petition pending for over 7 years, it is unfair and unreasonable to expect that the petitioner would have somehow preserved all the relevant documents, even as of date. Full stop. The court has it can reasonably be expected that sending the petitioner back to the authorities at this stage to produce documents which he does not have may not resolve the grievance of the petitioner at all. Full stop. It will only end up with the petitioner having to come to the court again, thereby multiplying proceedings. Paragraph. The recalculation of the amount due to the petitioner as 790 359
That is at page 44, if I may minus for a moment.
appears to be done indeed unilaterally. Full stop. As already mentioned, it is difficult to accept that the earlier determination of the amount payable as rupees 1636,285 was without verification of the documents submitted by the petitioner. Full stop. What is it, page 44?
That's page 44 is the analysis of the 7.2 lakhs millers that we had given. So it's based on calculations which have been made. Page 44 of my account.
But 43 precedes 44.
Yes, millers. 43 is pursuant to millers the contempt case.
Whatever, you have arrived at a figure there, 1636,285. After that, you're again asking for more documents.
No, that's page 44 of my counter affidavit. Because my lords, if I heard.
No, why didn't you see the writ petition?
Yes, my lords. I've seen the writ petition. 16 lakhs is what was there, and thereafter, my lords, 12 lakhs. But 12 lakhs, my lords, as I mentioned, was because we didn't have the itemized figures or the quantity.
No, you. How did you arrive at 16 lakhs without itemized quantity of figures? That's the mystery. It's not you're saying approximately 16 lakhs. Yes. You're giving a very precise figure. Yeah. As already mentioned, the actual date of completion of the project was 31/3/2009. That is nearly 14 years ago. Full stop. This is an additional reason why, at this stage, redoing the entire exercise would be pointless. So, thirdly, the petitioner cannot at this stage be relegated to a civil remedy, since that would be clearly time barred. Paragraph. Keeping in view all the factors, above factors, the court directs that the state will now pay to the petitioner the differential sum, that is 1636,285, as determined payable by it to the petitioner, minus the sum of rupees 7. $720,000 20359 within a period of 8 weeks, failing which the said amount would carry simple interest. Failing which the state will be additionally liable to pay the petitioner. Simple interest is 6% per annum for the period of delay.
Page 109.
You see, you have to add this from that. Even in terms of the clause 10 of the agreement, an extract of which is at annexure 5, the rejoinder filed with the petitioner. The petitioner is expected to preserve the documents only for a period of 1 year. 12 months, right? Then that is a simple interest at, that is the earlier payment will be together with 6% simple interest from the date of the earlier payment. What is that earlier payment? From 5/1/2015 till the date of payment, which shall not be more than 12 weeks from today. If the delay is beyond 12 weeks, then the state will be liable to pay further simple interest at 9% per annum for the period of delay. The petition is disposed of now.
Grateful.
Supplementary list, pass over item number 42.
But may I please, your lordship. But here is the second round of litigation, Lord. Earlier, the petitioner has approached this honorable court and this honorable court directed the Commissioner of Excise to submit the proposal to the state government. And now under Annexure 11, on 4th January, my lord, it was sent proposal. Till date, my lord, they have not taken decision, but the government has not taken decision for
The
grant of.
Excise Commissioner's proposal is at page 32,
Page
Annexure 11. And there is
But-
a, yes.
There is, my lord, also report of the, there is a Tahsildar report with regard to, my lord, distance factor of, my lord, from state highway. And there they have stated it is beyond 220 meters. So, my lord,
Because there are two reports, so there is, but what I beg to submit, so far as distance factor is concerned, from the
Got it.
page 33.
Yeah, got it.
So far as distance factor is concerned, the report of the revenue authority is to be taken into consideration.
Tahsildar's report is
That is
annexed
the
to.
letter number 2801 dated 28/10/22 of the Tahsildar. Tahsildar.
The petitioner's
So keeping in
representation-
view that, your lordship can direct the state government to dispose of the, to pass, to take decision on
State
the.
government means the secretary.
Yes, my lord,
Yes, yes.
Secretary Excise Department.
The Secretary Excise Department will examine the recommendation made by the Excise Deputy.
Recommendation of the
Annexure
Excise
11.
Commissioner
Of the Excise
Annexure 11,
Commissioner,
dated 4th January 2023.
dated 4th January 2023.
Taking into the distance factor as per letter number 280.
As taking into account the distance factor. As mentioned in
As per letter number 2801 dated 28th October 2022 by Tahsildar Kishan Nagar.
as per
At
the
page 33.
Tahsildar's letter,
Tahsildar
Okay.
Kishan Nagar,
Kisham Nagar's letter dated 28/10/2022.
28th October 2022.
And pass a reasoned order.
Within 15 days.
No,
we
no,
will.
by 15th of February, because my
By
lord, time bound is
Time bound
2
is-
months. In the meantime,
15th
1
February
month.
2023 and communicated to the petitioner within a week thereafter. The court clarifies it is not expressed any view in the matter.
Yes.
The petition is dismissed.
Obliged.
Pass over matter item number 70.
Event here, I have challenged the demand notice, the period, the 2 months, the license was not renewed. And here, them lord, under, at page 9, paragraph 9 counter, they have admitted that the shop was not renewed for 2 months. Annexure 7 is under challenge, my lord, at page my lord, 20. They have declared 2 months license fee, April and May. That 2 months has not been renewed. In the counter para 9, they have admitted, my lord.
So far as
So, my lord,
license
it's
fee is
covered by
concerned-
Bhagwan Mishra's judgment.
So
Lord, I have not
license
got-
fee is concerned, in order to maintain the continuity, he has to pay this. So, MGQ part can be taken into consideration.
But it is
as-
not renewed. If it is not renewed, how can they take the license? It cannot be continued, it will be there now, because it is a long since. My lord, this honorable court has stayed also, granted interim order. Because they, my lord, they did not renew. I approached this honorable court. After direction of this honorable court, they renewed the license.
This
After
factual-
4 months. This is for
factual
2 months.
dispute may
Another
be-
2 months also they have not renewed.
this
the
may be
demand is
examined
April,
by the
May.
Excise Commissioner and necessary order may be.
No, this is April, May is the demand, and June, July also not renewed, because in the month of July, this court, this honorable court directed for renewal. State the demand and directed renewal. Thereafter they renew. About 4 months it is not renewed, but this case is related to similar 2
Since-
months.
Since
And
there
they
is
have admitted
factual
in para nine.
controversy, your lordship may direct the Excise Commissioner to examine if there is any demand in respect of the closed, when the license was not renewed, then
It's
his
a covered by
prerogative.
Bhavan, Mr. Judgment. But today I couldn't get because I was out of Cuttack, so.
The challenge by present petition is to a demand notice dated 28th May 2015, issued by the Superintendent of Excise, Kionjar. Calling upon the petitioner to pay the
Consideration money. C money is
Yeah,
license
consider-
fee, my lord.
consideration money
Consideration money, license fee.
for and license fee.
No, that is same.
Both same.
Consideration money, license fee,
Consideration
same.
and license.
Consideration money for the 2 months of April and May 2015 and other charges.
Other charges. Other charges, my lord, after renewal, I have paid.
Including towards shortfall MGQ on IMFL/BEER for the year 2014-15. Paragraph. The grievance of the petitioner is that for the 2 months of April and May 2015, the shop was not operating. The IMFL off shop of the petitioner was not operating since the license was not renewed. But it is pointed out that only after approaching this court with a writ petition that under the directions of the court, the license was renewed after a gap of a further 2 months.
Lord.
It is accordingly submitted that for the said 2 months of April and May 2015, there's no justification in the department asking for the consideration money. Paragraph. The imputed demand is an appealable one. Full stop. Consequently, the court permits the petitioner to file an appeal against the said demand before the excise commissioner, who will, after hearing the petition on a date to be informed to the petitioner at least 1 week in advance, pass a reasoned order not later than 10th April 2023.
Not taking into consideration of Bhagwan Mishra's judgment.
Yeah, take into consideration the above factors as well as the orders and judgments of the court as may be placed before him by the petitioner.
Obliged.
The court clarifies it has not expressed any view in the matter. The petition is disposed of. Copy of this order be sent to the excise commission. And instructions. All right.
Item 7.
I'm filing the additional affidavit. The subject matter is that lease was sanctioned in the year 2000 in favor of the petitioner, only 15 decimal of land for the purpose of industrial purpose. And thereafter in 2015,
You should say that.
in 2015, after 15 years of lease, and the unit is running now, having 20 employees, they have issued a show cause notice, show motor revision case initiated, and the ground was taken that in 1997, during settlement, that was a kisam of Jalastra. But the lease was sanctioned in 2000, in the year 2000. And your lordship kindly have a glance to page 25. It is very clear. Page 25, I'm reading. The case is taken up today. This case was initiated an application received from Sana Industry, duly recommended by the DIC Jaipur for lease of the following schedule of land, which is more fully described below in terms of Sabak records. In Sabak records, it was also Patita in 63 settlement. And the lease was sanctioned by the collector Malkangiri by the order number 25/4/97 as per rule 11 of OGLS rule read with schedule 2. Item 3. Premium has been collected by MR number so and so dated 18/10/97. While the case was taken up to the execution of the lease deed, the settlement record was made for HAL publication. After revision settlement, the settlement authorities classified the land as Jalastra. Hence, the lease deed could not be executed in stipulated time. On receipt of the instruction from district office in letter number so and so dated 97 and letter number 963 dated 1/8/98, the classification was again changed to former classification as per rule 34C of the OSS rules. Copy of present ROR after effecting change has been annexed to this case records. Now it is necessary to condone the delay for execution of lease deed. According to para 5 of the lease sanction order, the lease deed should have been executed within 6 months from the date of sanction of lease 25/4/97. Hence, revised lease sanction order, considering the delay and incorporating the HAL khata number and plot number, etc., is necessary at this stage. Collector being the lease sanctioning authority, the case record is resubmitted to Collector Malkangiri for issue of revised lease sanction order in respect of following schedule of land in favor of Sri Sana Iron, Steel and Industries, Malkangiri. Priority Sri Proprietor Sri Tapan Kumar Sana. So, in 63, the land is of Patita Kisam and lease initiated in 95. In the initiation of 95, the land is Patita. Only in 97, because settlement authority wrongly make it Jalastra Kisam, so lease could not be executed, and thereafter it was again classified as Patita, as earlier settlement. And thereafter in 2000, they executed the lease and given me approval for construction. And thereafter I constructed and the unit is running and it is only 15 decimal of land. It also it is in the district of Malkangiri, where the Maoist area. And on that ground only in 2015, they have initiated the suo motu revision proceeding. And on this ground that they are showing one notification of 2013, Jalashraya cannot be used for any other purpose. That is not applicable to my case. Because when the lease was executed under Annexure 8, 2000, the Kisam of land was Patita. Only in 97 the Kisam was. And it is only 15 decimal of land.
As in 63 millage, it was Patita, but in the settlement, but in 1998, because that is millage. No, millage Sabik and Hal, millage Hal is post the settlement. 1997 millage, we find that it is actually Jalashraya.
I have given all the recent pata.
And therefore, millage that 2015. Mic is switched off. I'm sorry. Let's may kindly switch on the mic.
When was the lease executed in his favor according to you?
Annexure 8, 2000. 27/1/2000. Annexure 8.
That's 2000. Let's may kindly peruse my counter affidavit if I may.
Also in the lease deed,
Para 4, my lords.
also in the lease deed, your lordship, page 54, they have schedule of the land reserved above. They have mentioned this is all Kisam Patita. When the lease was also executed.
In 1995 millets, he had applied for setting up a industrial plant millets.
As recommended by the DIC.
1995 millets. And this was millets forwarded by the by the Tahsildar to the sub-collector millets with the recommendation of the DIC. Thereafter millets, as per order of the ADM Malkangiri with a letter number 30/12/1997, the then Tahsildar Malkangiri personally visited the site proposed. This is happening in 1997. Visited the site proposed to be delivered to the petitioner on lease along with local revenue inspector and Amin, and found that Sabik plot number 1542/2 Kisam Patita, as per Hull settlement, converted to a portion of Hull plot number 1706 is of Jalashraya Kisam. It is further specifically mentioned in the order sheet that the settlement authority have rightly recorded the suit land as Jalashraya. Is further mentioned that in his personal visit, he found that the suit land has been used as Jalashraya by the public both in summer and rainy days, and as such, the said land cannot be leased out to the party concerned. And with such observation, he has submitted the case record to Sub-Collector Malkangiri for cancellation of the lease in case number 3/1995. So, it starts in 1995.
95, the Kisam had not been changed.
No, it's
The
98.
change occurred only 98.
Yes, Milas. 98 it's changed, Milas.
When he applied for, it was still Patita.
It was still Patita.
Ah,
yes.
So you sit over his application for so many years, then change the Kisam, then what is he supposed to do?
In my affidavit, additional affidavit, page 10, the Tahsildar himself wrote a letter to the collector. I'm reading that part.
Milas, this additional affidavit has been served on me right now, Milas. Milas, I'll have to, if he's relying on it, they'll have to, Milas, take instructions. Maybe
I
I'll
don't know where it
reply
is.
to.
We don't seem to have that additional affidavit anyway.
Milas, he's just served me the additional affidavit. 24/1/2023.
Page 10, kindly have a glance. Page 10, this is the letter of the Tahsildar to the collector. The lease case number 3 of 95 was started basing on the application of Sri Tapan Kumar Sana, village Malkangiri. It was recommended by the DIC Jaipur by letter by their memo number so and so dated 94 to the Tahsildar Malkagiri. This come to the conclusion on 21/12/99 after signature of the collector Malkagiri on lease deed. Initially, the land in question was shaded in old master plan as industrial purpose also, as per the Sabak record. Subsequently, the settlement authority has recorded it as Jalasra. Previously, lease was sanctioned by the then collector Malkagiri on 23/4/97, but after obtained the sanction orders, objection was raised by the Tahsildar Malkagiri on 7/3/98, stating that the land in question was
Mr. Bali,
Jalasra in
it's
nature
better-
and he
it's
has
bet-
raised.
1 minute, it's better we take this on record then. You say Mr. Bali has handed over in court today an additional affidavit enclosing 4 documents, 4 sets of documents in support of the case of the petitioner. The copy thereof has been handed over to Mr. Mohanty, learned ASC, who's please for some time to respond to the said additional affidavit. We'll stop the statement also by filing a supplementary reply affidavit before the next date with an advance copy to transfer to the petitioner. Interim order to continue. List on 17th August in the regular list.
Item 8.
Contempt petition, you just say list on same.
If the petitioner challenges the demand notice, Annexure 5, page 19, Lordship, when the opposite party number 6 demanded 6 lakhs to the petitioner, the background of the case, Lordship, the loan was sanctioned, subsidy loan was sanctioned in favor of the petitioner for running a poultry farm. Out of 13 lakhs 41,000, 3 lakhs has been released in favor of the petitioner, and due to public hindrance, he could not.
You have other remedies, sir, against all this demand notice.
Yes, my lord. I am on behalf of opposite party no 6 bank. Alternative remedies before the cooperative registered cooperative society under section 68 of OCS.
Correct. Considering that the petitioner has an alternative remedy under section 68 of the Orissa Cooperative Societies Act before the registrar cooperative societies, the court declines to entertain the present petition. If the petition under the above provision is filed by the petitioner not later than 1st March 2023, accompanied by an application for condonation of delay, explaining the delay on account of the pendency of the present petition, will be considered by the RCS, Registrar Cooperative Societies, in accordance with law. If the application is filed within the time stipulated, accompanied by an application for interim relief, then till such time the RCS passes an order therein, the interim order passed by this court on 22nd December 2015 will continue. The petitioner's deposit of rupees 65,000 pursuant to the above order of this court will be accounted for while passing final orders in the revision petition by the RCS. The originals be returned subject to being substituted by attested photocopies. The petition is most of.
My name may be reflected, my lord. I have filed Bhakalatnama on 2/2/2016 by Dharu Sahu on behalf of OP number 6.
Item 9.
Item 9, my lord. If my lord permits, I will file a rejoinder. I have given copy to the government with my lord permission. This is a dispute between the government of India and the state government regarding 7182 land were given by the government of Orissa to government of India. Then via became BSNL 2000, land came to our control. Now the Tahsildar is demanding about 6 crores of rupees, even though the land was allocated in 2071-82 to us, to government of India. As per 285 article, no tax is payable, but I have paid the premium, etc. At that time, the government of India has paid. Now Tahsildar taking the plea that I have, without any knowledge of those documents, the local BSNL authority applied for a lease. On that basis, demanded about 6 crore rupees. So I approached the government of Orissa also. Annexure 18A of my lord's brief. Annexure 18A. Annexure 18A.
So you're coming at the stage of certificate proceedings.
My lord.
You did not challenge the original demand.
Yes, I have. Well, that demand is not based on I have withdrawn the application for lease. Annexure 25, I said on mistaken impression I applied for lease. But because of my earlier right given to the government to transfer deed, I am withdrawing the application. Annexure 25.
As counter has been filed, have been submitted the region.
Just only because you have filed application lease, you have to demand. That is the stand in the counter.
I'd suggest let it stay on board. I've received the rejoinder. Well, it's on Monday, I'll take it.
Rejoinder is taken on board. Stay on board.
Grateful.
Interim order will continue. Interim order.
Staying on board, we're not passing.
My lord.
Item 10.
May I please note? In 7/2/2020, my lord, notice has been issued to the opposite parties. No? And here, my lord, the question of law, my lord, the
Revisional order passed by the principal CIT. What is the revisional order? There's only one question. What the revisional order of the principal CIT?
Yes. And B also, the Innova assessment.
No, only one question has been framed, sir.
Yes.
5th February, only one question has been framed.
Yes. Lord, here the revisional authority, not only on the page 35, only on the ground is closing stock which has been referred and taken by the assessing lord, the closing of valuation of stock which has been taken by the assessing lord, that is not taking in the, though he has filed the statement of year-wise and the value has been mentioned, but the assessing authority without examining the invoices and sale of that year, he has accepted the stock in trade lord. And therefore, Lord, it has been returned back to the assessing authority to dean of assessment. And with tribunal, Lord, finding is, will also see that there is a consistency of the view of the petitioner, that earlier also that accounting standard they have taken into the closing stock.
Consistency, rule of consistency.
Rule of consistency, but fact remains, Lord, that the value which has been taken that year, he has not produced any evidence to that effect, only mentioning that the amount and certified by auditors, Lord, but that has not been examined. And so far as the Lord, without inquiry, Lord, the commission has the power to redirect for de novo assessment or know that judgment of the Supreme Court. But the fact remains that is the only issue your lordship took for consideration, Lord. And lordship please to issue notice, and somebody has appeared in this case, but
yeah, it's okay. The challenge, the present appeal by the revenue is to an order dated 12th September 2018, passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, bracket IT 18, allowing the SSC's ITA number 108/CTK/2018, whereby the order dated 17 March 2017 of the Principal Commissioner of Income Tax, Bhubaneswar, bracket PCIT, for the assessment year 2012-13, bracket, remanding the assessment proceedings to the assessing officer, bracket AO, was set aside. Paragraph. While admitting the present appeal, on 5th February 2020, the following question was framed for consideration. Take from the order. Paragraph. The background facts are that in the returns filed for the aforementioned AY, the assessee had shown closing stock at rupees 554,19,940, included gold and silver jewelry. Full stop. As per the tax audit certificate, the method of valuation of closing stock employed during the previous year relevant to AY 12-13 was open quotation at cost price or net realizable value, whichever is lower, unquote. Accordingly, there was no deviation from the method of valuation under section 145 capital A of the Act. Paragraph. According to the audit report, according to the department, valuation of closing stock by taking the cost price of the opening stock was not an acceptable method where purchases had been made during the year. Full stop. The principal CIT in the impugned order was of the view that there was no material available on record to substantiate the basis on which rates of closing inventory were arrived. Full stop. Since according to the PRCIT, the AO failed to properly examine the issue, invoking the power under section 263 of the Act, the PRCIT set aside the said assessment order, and remanded the matter to the AO. Paragraph. The ITAT has in the appeal noted that in the original assessment proceedings, they had in fact made inquiries in respect of valuation of closing stock. Full stop. Further, for the subsequent AY, no, full stop. Further, the SSC was consistently following the same method of valuation of closing stock earlier in the earlier years, as it was following in the AY in question. Full stop. Profit was reduced according to the method adopted by the SSC. Full stop. Paragraph. Holding that the PRCIT was not justified in disturbing the consistent method of evaluation adopted by the SSC. The ITAT set aside the order passed by the PRCIT. Paragraph. Having heard Mr. Satpathy Leonard, Senior Standing Counsel for the Department, and having perused the impugned order of the ITAT, the court finds that indeed the SSC had been consistently following the same method for valuation of closing stock as was done in the AY in question. Full stop. It was incumbent on the AO to have accepted this consistent method of valuation, even by the rule of consistency. Full stop. There was no material to come to a conclusion that SSC had tried to evade any payment of tax by adopting the aforementioned consistent method for valuation of its closing stock. Paragraph. In the circumstances, the question framed is answered in the affirmative, that is in favor of the SSC and against the department. The appeal is dismissed, no order systems.
Item 11.
In this case, I am appearing for the opposite part number 4. I am submitting a date set and some judgments of the. All right.
I am also submitting little facts are required.
Yes, sure.
Will your lordship kindly please to see in my page 2 of my
my compilation, my lord. I am
you are performed. Please, Lord, will your lordship be pleased to see page 2 of the note of submission of mine, just to know and note down the genealogy, which would be a relevant factor for subsequent decision of this case. Page 2 of my notes, my lord. Kindly see, my lord, the top led Gangadhar Sekhar Deo, and in that they have 3 sons. The right hand Sitaram Sekhar Deo is his legal heirs are the petitioners before your lordships. And in the left hand side, my lord, Digambar and his son Badrinarayan, who is since dead, his eldest son Kartika Sekhara is the OP number 4. But what has happened, my lord? Exercising the powers of the law of primogeniture, that means the eldest son is only eligible, no other person is eligible. The appellate authority, I'll come to the facts, in the face of various decisions of civil courts, to the contrary, has given the entire property to OP number 4. Excluding Mr. Rothar represents the second branch, that is Pitambar Sekhardeo. His son is OP number, Mr. Rothar. All others stand in the same footing, 7 except the OP number 4, because the entire property has now been directed to be given by the appellate authority, exercising the appellate authority in the sense, my lord, what has happened in this case. Now your lordships can go over to, I'll just give your lordship a brief genealogy and the facts. But this property, which was a Kharfos grant in the Hathiwari estate, all these facts are there in the written notes. Only I'm saying that they were attached to the Court of Wards way back in 1941-42, Court of Wards. But after it has been attached to Court of Wards, there is a dispute arose between the parties relating to the rights. And my lord, in 1948, my lord, 1948, in the list of dates, it will also find that that 1940, your lordship sees, my lord, I'm sorry, my lord, 1994 would be an incorrect date. It would be, your lordship may ignore the dispute arose between father and petitioner. That would be an incorrect date. That would be 44. Anyway, let that nothing boils in that. Lord, then your lordship is 46. In the Gangpur state and the Gangpur High Court, the dispute arose about whether the property will devolve under co-personal rights or it will go to exclusive rights. And the High Court of Gangpur, in which the father of OP number 4 was a party, decided that it is a co-personal right. Lord, straight away I will take your lordship to that fact where it is. Your lordship get it at page 15 of the brief. Kindly see page 15. Page 15, my lord. It starts at page 15, my lord. The issue was whether it is, if your lordship sees the issue, page 15, it was the High Court of Gangpur state. But those states had their own high courts prior to independence. But the first issue of lordship is, and the Roman, the first issue framed by me runs as follows: does the property in dispute called the Hathiwari Ilaka form part of an impartible estate descendable to a single heir regulated by a law of prime minister? That was the question. The owners on this issue, etc. My lord, your lordships sees thereafter that the decision. Yes. The page yes. My lord, page 52. Page 52. I'm not taking lots of the details in the discussions. In page 52. On the date of Ganga Sekhardeo is the original, my lord. His two sons and the two sons of his predecessor son were entitled to succeed to his property in accordance with Hindu law. The share of each son was 1/3. The state of Gangpur decided way back in 46 is that this is a partible estate where each of them are my lord, lordship seen that? Thereafter, my lord, the father of OP number 4 filed a review that against that order, and your lordships get it. The review is there. At page 59, the review was dismissed. Page 59. Against this finding, after giving the matter my post-anxious consideration, I have no hesitation to holding that there is no grounds for entering the review, and the review was dismissed. The party, there was also suits in the High Court. That means post-independence. Your lordships get it. Page, your lordship, page 73. Yes, my lord. This is a suit of our High Court, Lord. Your lordship get it. This is as 73. This is an appeal of defendant number 1-3 against the final decree of subordinate judge of Sambalpur in a suit of accounts. But then your lordship, more important is page 74. Each of the three sons, the lordship got it, page 74. Each of the three sons of Gangadhar is admittedly entitled to 1/3 share. The estate was, however, taken over by the Court of Wards. The civil courts, my lord, decided everybody, but there are various civil court orders, not one. But yeah, I'll take your lordships to the other civil court orders order. Then your lordships page is page 87. This was the page 87, Lord. This was in the final decree proceedings in the suit, Lord, page 87. Page 87 is the relevant page, Lord. The suit coming on this and the final disposal, etc., subject Sundargarh, both the parties and etc. It is ordered that a suit be decreed preliminary against the defendant number 1 to 9 on admission is caused in defendant number. The suit property divided to a civil court in 3 equal parts. 3 equal parts. Lord, this is a very important document to the lordships like to see at page 88. Page 88.
Yes.
This estate, Lord, was vested under the state, under the Estate Abolition Act. As the lordship knows, the law is, if the estates are vested under state, they are vested in the state free of encumbrance, and the state can confer intermediary rights on the persons who are in possession. Lordship get it at page 88. This estate was vested. In Lordship sees in exercise of powers conferred by subsection 1 of section 3 of Odisha Estate Abolition Act, as subsequent amendment, the government of Odisha do hereby declare that an estate specified below has passed and become vested in the state of Odisha, free from all encumbrance. And thereafter, my lord, it was fixed on the name of intermediaries. Your lordship get it from 1 to 9. We all are intermediaries, lordship. We all are declared as intermediaries by the state. This is by the government notification, my lord. Then your lordships get it at page 89. This is important, my lord. Page 89. Lord, this is a letter written by all the co-sharers, including OP number 4, who is in the top. We, the following persons, are the co-sharers. Lordship got it?
Yes, yes.
Yes, Lord. In the meantime, co-sharers filed partial suit to divide the properties. In that suit, the parties agreed to the suit to divide, and hence the suit is decreed. Accordingly, a preliminary decree and final decree is passed out of partition of the properties by metes and bounds. Therefore, the parties want to hinfetan, etc. This, your lordship sees, petitioners, the top person who has signed is OP number 4. Persons who are now claiming exclusive right on the basis of primary deal. Lord, then your lordships get as page 131. Lord, 131 is another, in the consequently, Lord, the final decree proceedings and the commissioner's report was accepted by the parties. The suits were divided between different branches. After going through the preliminary, you will also get it at page 131. After going through a preliminary decree and the commissioner's report, hereby ordered that the preliminary decree is made final. The commissioner's report, along with allotment seat, as do form in the meantime, above to bear their own effective cost of proceedings. This was the background, my lord, page 131. But what happened, my lord? These are the suits and decrees final passed. Lord, so far as the law is concerned, my lord, Mr. Ratho is also supporting me. He will explain if I have any difficulty in explaining to that. But my understanding of the law is, Lord, after the Hindu Succession Act came into force in 1956, there is no law of primogeniture unless that law of primogeniture is saved by any customs or any treaties. If there is any treaty to the contrary, that is 4 and 5. Section 4 and 5 of the Hindu Succession Act, Lordship sees, save as Section 4, save as expressly provided in this act, any text, rule, interpretation of Hindu law or any custom. Primogeniture is supposed to be a custom. Or you say the part of law immediately before the consult shall cease to have effect with respect to any matter for provision, unless there is, my lord, what they say, my lord, some judgments I'll place to your lordship's necessary. So that if this can be overruled by Article 363, that if there is a treaty, that means, my lord, if a particular kingdom is given under certain parts under treaty, then it will override the Hindu Succession Act, not otherwise. There's no treaty, no treaties or anything are involved in this case. But this would be section 4, your lordship says, 5, that any succession is to be ruled by a co-partner, and Hindu would be after 1956 Act came to force. Now, notwithstanding all this, notwithstanding these decisions of civil courts, notwithstanding these final decree proceedings, what happened, my lord? OP number 4 had approached this court to say that the matter which is pending before the Court of Wards should be released. What the court said in the High Court, that it should be released and the authority may consider who is the person entitled to receive it. But the Court of Wards in this case is the Tehsildar. And the Tehsildar decided that we all are entitled to according to our rights. Against that, my lord, he preferred an appeal to the ADM. I don't know what circumstances ADM, at least I couldn't lay any hands on any power being exercised by ADM in the appellate authority because they are not judicial authorities. They can't stand in. He said, he went it and said that the civil court decrees are not binding. These are not binding. And he awarded that entire thing to be OP number 4 on the basis of law of primogeniture. That is the point for which I have come before.
There's no law of primogeniture anymore.
There is no law of primogeniture anymore. So law of primogeniture is the basis on which has been given. And my lord, one other thing your lordship must also keep in mind while this, during the pendency of this case, most of the properties which is attached to this Court of Wards have been sold by OP number 4 itself. That's another matter for the consequential.
What is left now? How many acres?
There are properties, vast areas. So all will be getting some shares.
Well, you don't want to settle, you don't want to go for mediation. You want to be keeping all lawyers busy and rich. 25 years of litigation, sir.
This is long.
One generation is gone.
Yes, it's all legal heirs now.
All
legal heirs.
The legal heirs of
legal heirs and legal heirs. Legal heirs and legal heirs.
Why don't you put a value for this whole thing?
That is, in fact, an ideal proposition. But then I don't know if my
Samal must be.
He's the primogeniture.
But if your lordship kindly see the ADN.
You are OP number 4.
I beg pardon, I couldn't follow.
No, you are OP number 4.
Yes, I am for the OP number 4.
So your magnanimity is what is going to decide the fate of this.
In fact, this is a proceeding initiated under the provisions of the Court of Wards.
No, legality will examine, sir. I'm on something else right now.
Yes.
You can, if you want to talk to your client and respond, you can do it. I'm only asking for generations to come. You want to be litigating or you want to give peace to your future generations?
We'll sit with Mr. Padi. I will sit with Mr. Padi.
You have some rough back of envelope evaluation done of the property.
Yes.
And then
I will sit with Mr. Padi. Yes. I have no issue.
Exclude me or what?
No. We all will sit with Mr. Padi.
The more you exclude, the more trouble you invite.
No.
I'll just only request your lordship that kindly make a such orders which will force the clients to go rather than give them an option.
And the most interesting
party number 10, lordship.
10. And the most interesting part is that, as directed by your lordship, my Tehsildar has filed an affidavit last date. Most of the land are sold.
No.
They are all sold contrary to your order.
My lord, about some percentage of land has not been. Substantial land are in with the.
I have given a chart.
My lord, in fact, your lordship directed the earlier occasion to the Tehsildar. Way back since 2008, the movable and immovable properties have been attached. They are not furnishing the list of movable properties because they kept in a treasury. I don't think those are available. Despite your lordship 2008 order, this Honorable Justice Chauhan, while hearing two sittings, Honorable Justice Chauhan was sitting over the matter, had taken up the matter and directed.
Instead of joining issues there, as your lordship rightly suggested.
I am saying there is a specific direction by this Honorable Court to provide the list of properties which was attached taken by the Court of Wards, both movable and immovable. They are not furnishing till date. Your Lordship, order number 42. Your Lordship may kindly have a glance to order number 42. By the date, Mr. P. Ponda, Additional Standing Counsel may instruct from the Tahsildar and he may produce the list of property, both movable and immovable. And prior to that also some order was passed to produce. And then on 19/3/2009, by that time the Lord and Standing Council of the state shall take instance and directed earlier. My mother's jewelries have been taken from by the court of arts. They have kept in the court of arts. The entire furniture, fixtures, everything has been taken by the court of arts. That is kept in a seal by the court of arts manager. No list has yet been produced. Let them produce this. These are the movable properties taken by the court of arts.
May 22. After that, has the Tahsildar filed an affidavit?
Yes, on 23rd November 2020.
No list of movable and immovable. There is no mention of these are the properties which has been attached in the year 1943.
23rd November. Pursuant to the order dated 9th May 2022. Para 7.
State has filed an counter affidavit before this honorable court way back in 1985 in the earlier writ application to release the property.
Tell me the date again, 23rd November.
23rd November 2022. So I have a copy of that, my lord, if I can give you. 24/11, I think.
11.
23rd 11.
November.
Yes. That is affidavit filed.
It is e-filed.
It's not come on record.
नहीं जो काफी record.
Data council is what's your pictures? Right. What is machine
mediation को पठा दो.
Who has got the relevant records or the property documents? You have it?
No. My lord, in that affidavit at page 10, regarding to the Tahsildar Kuarmunda, regarding submission of movable and immovable properties and all related document in connection of Hattiwari Court of Arts, OJC number so and so. With reference to subject matter, I am enclosed here with the required information. This is for your kind information, necessary action. Next page is nothing.
Nothing means some endorsement.
No details. No details. My lord, I am referring to that affidavit, page 10.
No, what is written over here?
This is regarding submission of the movable and immovable properties of all related documents. The next page, आपनका आदेश मुताबिक कौनसी तथ्य पाइलु नहीं, we could not find any document.
That is the information.
My lord, they have taken our properties, both movable and immovable. They, without making any search, technically they submitted that we could not get any documents.
That is all right.
They were putting the land to
No,
auction.
but tell me one thing, how can so many transactions of sale take place? if there were no
And he
documents?
has only done it.
No,
Despite the
not-
injunction
not
order
only
passed by
I,
the
all the parties, my lord, all the parties, their names have been indicated. All the parties have sold, they are in a poverty-stricken state of mind. Before the.
No, 1 minute. KK Shekhar Dev is you.
Yes.
So just let's come to annexure A2 series.
A2 series. Page 4.
My lord, towards last, Leelapati Singh,
No,
Leelapati Singh.
we'll come to all of them.
Yes.
KK Shekhar Dev is a vendor in at least 20 to 30, I think.
Yes.
20 to 30 parcels of land.
So also the petitioner.
No. Sir, please.
Yes,
Not
yes,
excluding
right.
anybody.
No.
Just finding out.
I quite agree with your lordship. Substantial land has been sold by my client. I do not say no. That is before the order passed by this honorable court and after release of the property in his favor.
Injunction order
No.
kind of similar.
No, I'm just wondering how these sales took place without documents. It's inconceivable that any sale took place without documents.
Yes.
Nobody's going to register a sale deed.
And exercising the primogeniture right, entire property taken. 2 of the branches are left with nothing. Nothing. They are starving. 2 of the branches and their children are starving, and this particular eldest branch is selling away all the property.
The eldest branch is entitled to get the entire properties.
Let us then your lordship see the ADM's order.
Yes.
May I make a submission to your lordship, subject to your lordship's consideration, not today. All parties have filed notes, not the way it is going on for last so many years, it's, to my mind, it's extremely difficult for them to
Yes,
go to a
yes.
solution
Not
at all.
cannot.
Because they have sold, this has sold. Not today, Lord. All the notes have been filed. Your lordship may put a convenient date at 2 o'clock. See, then give a quietus to the matter. Either way. Whoever, he has a right, we have a right, we have a right. So I think your lordship may fix up sometimes because these are only
because the problem will not get resolved. I'm saying, suppose we agree with you that law of primogeniture does not apply.
Yes. Right.
We can't reverse all these transactions.
That is for the consequences will follow. The consequences because these sale deeds have been done.
No, then it will be an intestate property of the ancestor.
Yes.
Then you have to trace all the class 1 heirs at each stage.
So what happens, my lord? Supposing your lordship decide the rights only and leave the matter as it is, then there will be 2 aspects. Properties which are left over, then the properties can be enjoyed by the whichever is the rightful owner of the parties. The property which is not left over, that means sold in contrary to your lordship's injunction order, the law will take its own course whether the invalid sale. But I think instead of, I think parties, after so many long years and so many difficulties, but I think your lordship may give a quietus to the entire matter. I mean, convenient to your lordships, and because the issue is small, the records are big. Issue is whether law of primogeniture is applicable or not applicable. If your lordship can decide either way, depending on the law and the facts. So I think, may I pray, my lord, we all pray, my lord, instead of parties would normally would not come to any, I mean, it will only further delay the matter. Only your lordship, because this, may I say, so get respect, my lord, this is 97 matter.
That's what.
Many times this matter has been listed, it has been not been able to
be resolved.
So will lordship fix up any date, not today, where these facts are clear before your lordships. And lordship can take up at 2 p.m. or 3 p.m. and this is the only issue. Let him answer.
All of this is Sundargarh district, is it?
Yes.
Yes. Because their person, in the meantime, Tahsildar can be asked to give the details of
No, but even here, Mr. Mohanty, while he's given us a list of properties that have been sold,
yes,
what is the remaining property left? That is not clear.
That I will try to get this.
Because without that, we cannot injunct for the sales.
And that
if quietly are still selling,
injunction order is very much there, but
now your lordship, I think, passed also an order.
Today, that is the 9th
Last
of
order.
May 2022.
Last order, your lordship have restrained.
that is already there. Injunction order is already there.
7.
Yes, para 7, my lord, in the courts reads it, the earlier interim order directly not to alienate. I think now the Tahsildar has written
Now
to the
all these aliens are
sub-registers-
restricted.
Sub-registers and other not to do anything further. So this restraint order is now acting, my lord. It's in force, but earlier orders have been violated. So may I just be grateful.
All right, pursuant to the order
My
dated.
lord, may I submit one thing? The original case record of ADM is available with me. Let me submit before your lordship.
Yes, yes.
Your lordship
Keep
may
it in the seal cover.
Yes, we'll keep it. Your lordship may record that I am submitting the original
All right.
case record in respect of appeal case number 11 of 93
Okay.
of ADM Sundargarh.
The original case record of
Appeal case number 11 of 93.
appeal case number 11 of 1993 of the ADM Sundargarh
Yes.
has been brought to the court by Mr. D.K. Manthi, learned AGA. The said record is directed to be kept in a seal by the Registrar Judicial and not to be parted with till further orders. Then next, we say pursuant to the order dated 9th May 2022, an affidavit has been filed by the Tahsildar Bir Mitrapur, dated 23rd November 2022, where inter alia he states that the Sabak records were compared with the Hull records, and it was noticed that there were several transactions made by the family members of the petitioner. List of Annexure A2 series enclosed with this affidavit lists out several such sale transactions undertaken by the various family members, including the petitioner, of in Nuagaon, Karimati, Ankurpalli, Dunia, and Lale Khabar. Paragraph. It appears that
Lordship may note that any
But the Tahsildar filed an affidavit in respect of 4 villages, but in respect of 7 other villages.
That's what I'm coming to it. I'm coming to it, sir. It must be noticed at this stage that flag 25, is it?
Flag 28. Flag 28.
All right.
Paragraph 2.
Right. 1 minute, sir. 1 minute. That the petitioner, that opposite party number 4 had filed an additional affidavit on 13th February 2007. Stating that the Kinjiri estate was having 64 different villages. Full stop. Of these, 11 were Kamar villages, namely Gogia, Balimunda, Kokerama, Ankurpalli, Nuagaon, Joketa, Karimati, Lukumbeda, Donia, Lale Khaman, and Hadibari. Full stop. It was further stated that apart from the Kamar villages, there were several Gaunti villages. Full stop. Further, for the maintenance of the junior branch, the Kharposdar of the estate had granted the Kharpos village in their favor. Full stop. The above affidavit of the Tahsildar dated 23rd November 2022 does not list out the properties that remain in the estate after alienation of the above parcels of land. Stop.
My lord, may I submit one thing? These villages, after the bifurcation, these villages are now coming under another Tahsil, Kuarmunda. So that is why Kuarmunda. That is why perhaps this instruction
Yeah,
is
yeah.
only.
Mr. D.K. Manthi, learned AGA mentions that after further bifurcation for administrative reasons, some of these villages now fall under the Tahsil Kuarmunda. And therefore, the Tahsildar B. Mitrapur may not be in a position to ascertain their status, the current status. Paragraph. Although this court had reiterated on 7th May 2022, the earliest status quo order of 24th May 2004, and instructions have been issued on 2nd November 2022 to the sub-registrar Bir Mitrapur not to entertain or allow any transactions of the case land.
That is, we are following that.
It is necessary to also injunct the sub-registrar at Kuarmunda likewise. Paragraph mentioned here that according to
I
the
think there is no sub-register in Kuarmunda, I think. Kuarmunda is a small village. Tahsildar. Sub-register is not in all places. Anyway, Lordship may direct that.
It must be noted here that by letter dated 29 September 2022, the Tahsildar Kuarmunda,
my lord,
has
I am
reported,
extremely sorry, my lord. Kuarmunda and Panpos, another Tahsil.
and Panpos.
In the
Tahsildar Panpos at Kuarmunda, it says.
yes. Panpos at Kuarmunda. Correct.
Tahsildar. Record keeper at Kuarmunda has informed the Tahsildar Panposh at Kuarmunda on 29 September 2022 that there are no records relating to the case land available there. Full stop. Paragraph. Keeping in view the above developments, the following directions are further issued. 1. There will be no altering of the status quo in respect of any of the case properties hereafter. And the earliest status quo order passed by this court on 24th May 2004, as reiterated on 5th November. On 9th May 2022, he is hereby again ordered to be maintained. 2. The sub-registrars of Bir Mitrapur, the sub-registrar of Bir Mitrapur and his counterparts, if any, in the other tehsils of Panposh at Kuarmunda, will not entertain or allow any transactions in respect of any portion of the case land. 3. The Tahsildars at Bir Mitrapur and Panposh at Kuarmunda will make an effort to draw up a complete list of the remaining properties forming part of the Kinjri estate and submit a report to the court as to the present status of those properties. That is, who's presently occupying them and what are those properties being used for. We'll stop. The value of such properties will also be estimated, and those details shall also be placed before the court along with that status report. Next, the Tahsildar of Bir Mitrapur as well as Tahsildar of Panposh at Kuarmunda will jointly file an affidavit placing in record status report before the next date, placing a record status report along with the above details. Paragraph. Notes of submissions have been submitted on behalf of the petitioner. Opposite party number 4 and which is the third one?
9. I'm for 9.
And opposite party number 9.
I am for 10, Lordship.
No, convenience compilation.
I have given. Legal errors of question number 9.
Full stop. Paragraph. Counsel with the parties have been asked to consult their respective clients to examine if they would be willing to go in for a mediation and inform the court on the next date. Full stop. List on.
My lord, may I request one thing? Your lordship may direct that the collector Sundargarh may be directed to ensure compliance of this.
The collector Sundargarh will ensure compliance with the above directions of the court.
And this order may be communicated to the collector.
List on.
Minimum 3 months time may be granted. कौन करेगा इसके काम को केमती करेगा?
Is it possible sometime in April, my lord? Because of the
4th May, sir, at 2 p.m.
At grateful, sir.
4th May at 2 p.m. A copy of this order shall be sent to the collector Sundargarh forthwith for compliance with the directions.
Item 12.
Item 12 on behalf of Mr. H.N. Mahapatra, no instruction.
No instructions.
Obliged.
Item 14.
14 may I plead, my lord. 14 here challenge the rejection of my claim for a one-time settlement. At flag B, I filed an IA for implementing the private respondent. As
This is pending in the DRT.
No, this is
in the DRT or not?
no. The petitioner has approached this honorable court, not in the DRT, my lord.
Sir, you're not understanding the question at all. I don't know what you're hearing at all.
Has the bank proceeded?
No, my lord. Bank has not proceeded because there's a stay order, my lord.
No.
There's a stay order operating since 2011, my lord.
Who's appearing for Indian Bank? He will tell us.
Mr. Tuna Sahu was appearing on the last occasion, my lord. On his submission that the death has been taken over by a private bank, my lord. And
asset company.
Yes, my lord. On the last occasion, I've taken time to implement that company as a party, and to that I've filed an IA at flag B, my lord. The entire loan has been taken over by that company.
So if there are no proceedings pending in the DRT, then why should you worry?
Because there's an order, my lord, 24/10/2011. There's a stay order, my lord.
State. So why should we continue to interfere? If it's been taken over by a private company and they have not sought to enforce the debt, we need not interfere.
Because of the fact that on 24/10/2011, this honorable court has directed.
That party does not know all this. The new company is not aware of all this. They are not even a party to these proceedings.
My lord, I am interested to take over my land, my lord, by paying off the rest of the amount.
When will you pay it? Then we'll immediately undertake, record your undertaking. How much is the amount with the interest now? And you deposit it here.
That interest first the company has to tell, my lord.
What is the total loan amount? Original loan amount?
Original loan amount was of rupees, my lord, 5,37,000.
You put compound
34 notice was issued in the year 2011, my lord.
No, you got a stay for just depositing 50,000 rupees, which is nothing. You put it even 15, 17% or 18% must be the bank interest. You deposit that entire amount in this court, then we'll consider.
That instruction I have to take from.
No. Instruction we can pass over, you take from on the phone. Ask your client What is your client's assets? What is his age?
Right now, he's
What is his age? What does he do?
a small-time farmer, my lord.
So will he be able to pay 40 lakhs, 50 lakhs?
That he will not be able to.
So you don't even have to take instructions. You can imagine what will happen.
Around 63 or 64 years of age, my lord.
He'll be in no position to pay even this another 50,000, if you ask me. It's best if we just close this matter. If that asset new company moves against you, you seek appropriate remedies at that stage.
That liberty may kindly.
You say the petitioner had approached this court at a stage when the previous lender, that is Mrs. Indian Bank, had sought to enforce the had sought to recover the outstanding amount of around 636,923 borrowed by the petitioner as on 30th June 2010. Stop. So, an interim order was granted in favor of the petitioner, subject to his paying rupees 50,000 to Messrs. Indian Bank, bracket opposite party number 2, paragraph. The petitioner has filed IA number 11361 of 2022, seeking to implead the Asset Reconstruction Company, bracket India, bracket Limited, which apparently has purchased the debt of the petitioner from Messrs. Indian Bank way back on 25th April 2011. That is more than 11 years ago. Paragraph. Considering that till date, the petitioner has not received any notice from ARCIL, it is evident that the petitioner faces no immediate threat of recovery of the loan. Stop. As and when ARCIL seeks to recover the outstanding loan amount, it will be open to the petitioner at that stage to seek appropriate remedies in accordance with law. The petition is disposed of, the interim order is vacated.
Item 50.
Please, Your Lordship. Here is a matter of challenging the order passed by the Industrial Tribunal. I am the constitutional level assistant secretary. The award is passed in favor of compensation of 10,000 only, my lord. In 2008, then I filed the petition 2011. Your Lordship also direction to the opposite party to deposit 10,000, my lord. Last occasion, my lord. Your Lordship, the past order without negligence, only misconduct that has the reference the service, my lord. Your Lordship, go to the order. There is nothing against myself. Only the misconduct of the petitioner returns the order, returns to the petitioner from the office. And this so Industrial Tribunal also passed an order for my on only 10,000.
The order that we made on 7th December. Are you aware of the order that we passed on 7th December?
Yes, my lord.
Where read the order, sir.
My lord. Why is not my here, my lord? That you also direction to 10,000 deposit the opposite party, my lord.
Sir, do you have a copy of the order dated 7th December?
Sorry, my lord. I have no order, my lord. Sorry, my lord.
So we'll help you, sir. Just take out the hard copy. In your own matter, when there's an order in your client's favor, you don't keep a copy.
Sorry, my lord. I said
you don't have to be sorry to me. You have to be sorry to your client. Read carefully and slowly the first paragraph. Not silently, sir. Read it loudly now.
My lord, learned counsel appearing to opposite party number 2 states that to the best of the knowledge, there is the incident whether the petitioner
There
is
is,
still around.
one minute, there is?
Learned counsel appearing for the petitioner is unaware of any development in this regard.
1 minute,
And
sir, you're just skipping, you're in a hurry or something?
No, no, my lord.
Ah, why? You had good lunch or not?
Yes, madam.
Read
Learned-
slowly and don't swallow words.
Yes, madam.
Ah.
Learned
Best of
counsel
his knowledge.
No, 1 minute, learned counsel appearing for, read slowly and loudly.
Learned counsel appearing for opposite partner 2 states that to the best of the knowledge, there is uncertainty whether the petitioner is still around.
Full stop. What do you have to say to this?
I leave my lord.
Huh?
I leave my lord.
What is it?
Alive, my lord.
Alive.
Alive, my lord.
When did you speak to him?
My lord.
When did you speak to him, sir?
Mr. Nath.
Yes, my lord.
When did you speak to the client? You spoke to him or you did not speak to him?
Yes, my lord. I consulted the mobile phone also 2 months back, my lord.
2 months back?
Yes, my lord.
We asked you this question only 1 month ago. Oh, 1 year ago, is it?
Yes, my lord. Yes,
All
my
right.
lord. Yes, my lord.
What?
And also, my lord, opposite party sold deposit 10,000 rupees, my lord. This on the report, my lord.
1 minute, just read on, sir.
My lord. Learned counsel appearing for the petitioner is unaware of any development in this regard and seeks time for insertion. He is also unaware whether the petitioner has been paid the sum of 10,000 that was awarded to him by the industrial tribunal in the informed award. Second, if such amount has not already been paid to the petitioner, opposite party number 2 will ensure that the aforesaid sum of deposit of the court before the next date. List that matter in 1st February of 2020.
Mr. Nath, your reading, you have to improve your skills.
Yes.
You're skipping words. These are all in favor of your client and you're skipping them. All right, pursuant to the above order dated 7 December 2021, a demand draft of rupees 10,000 has been deposited in this court by opposite party number 2, who today does not appear.
I have appeared, man. I'm here.
You're here. Oh, very good, sir. Very good. You're so silent and watching, so we're wondering whether you're here or not. Very good, very good, very good.
Due diligence I have deposited.
Very good, sir. The said amount shall now be released in favor of the petitioner upon proper identification by the registry forthwith. Full stop. No further directions are called for in the present petition. It's disposed of. All right.
Item 16.
You took back the file or is carrying the file?
I don't have the file and my learned friend is also having no file.
But
So we have
I have
noted
collected
down.
the court's file.
I have noted down from your lordship's file.
My lord,
And-
before my learned sister starts, let me submit one thing, that this is a year-old case of 10 years. We have not filed counter affidavit. That is admitted. And she has raised a very sensitive issue that the petitioners have got usufructory rights over the land in question. There was a agreement or a letter of the Tahsildar that whenever the land will be required for the developmental purpose, they will be compensated. But now they allege that we have not been compensated and the aims.
They can make a representation.
Yes, that the collector wants, the collector may be given chance to.
All right.
Yes, that
The
representation is that one.
court notes that there is already a representation dated 4th November 2011 by the Jibika Suraksha Committee Kansapada
Yes.
to the
Collector Khorda, he is the authority.
to the Principal Secretary SC and ST.
No, my lord, that collector.
No,
may be
1 minute, sir.
Yes.
Which was somehow not attended to, and therefore the present petition was filed. Paragraph 2, in the pendency of the present petition, no counter affidavit has also been filed. Full stop. There was an interim order passed on 4th April 2012 stating that trees standing on the land, if any, shall not be felled. Full stop. Thereafter, there has been no development in the present case either. Paragraph. Since no reply has been filed by the state government to contradict the pleas of the petitioners that lands have been taken away for the purposes of IIT Bhubaneswar.
No, their land. Land is government land. They have got on the basis of Annexure 2 series, they claim that we have got usufructory
Okay, the
rights.
land which has been taken over for IIT Bhubaneswar that they had usufructory rights.
Yes, madam.
Over the land which has been taken for IIT Bhubaneswar. The court permits the petitioners to make a fresh representation
Madam,
to the collector,
Madam, may I
Khorda.
only
Khurda.
one collector Khurda. There is a condition in that.
That he will take care of everything.
Condition number 12. That may
Placing
be
on
taken
record,
care of.
no, enclosing all documents that are available with the petitioners and raising all the contentions that they wish to raise, including the contentions raised in the present petition. If such representation is made not later than 1st March 2023, the collector Khurda will, after examining the said representation, and issue notice to the petitioners.
Hearing the petitioners, there are lot many petitioners.
29.
29.
So
A
for
few,
their
yeah.
convenience,
Yeah.
only one of the representative of the
That is okay.
Yes.
After hearing a few, two representatives of the petitioners, who will be nominated by the petitioners themselves, pass a reasoned order, not later than 3rd July 2023, and communicate the order to the petitioners within a week. The court clarifies it has not expressed in view of the matter. The petition is disposed of. A copy of this order be sent to the collector Khurda forthwith.
Obliged, madam.
Item 17.
Item 17 on behalf of Mr. Ratha, he logged on his election code number 1. That is on next week, madam.
We'll stay on board.
18.
My learned seniors, one of my relative has been hospitalized. So
Stay on board. It will stay on board. All right.
Next week is
19.
May I please? Lordship, the petitioner here challenged the petitioner management before the learned tribunal had filed a petition to take up issue number 1 and 2 as preliminary issue. That is at annexure 11, page 38. The prayer in the petition was, it is therefore humbly prayed that this honorable tribunal may be graciously pleased to allow this petition by taking up issue number 1 and 2 as preliminary issue, and for such act of kindness, the first party management shall as in duty bound ever pray. Issue number 1 pertain to whether the petitioner management is an industry or not, and the second issue was whether it is a case of a retrenchment or not. To this, the objection of the opposite party workmen is page 39, annexure 12. Their objection was that there cannot be any piecemeal adjudication. However, the impugned order, that is annexure 13, page 40, the learned tribunal, while answering that petition, has already answered the issue number 1, that whether the petitioner management would be an industry or not. Whereas no such petition was made, neither arguments were advanced, and we are not given opportunity to hear. So this will ultimately affect the merits of the matter. So what I propose or submit before your lordship is that if the matter is remitted back to the tribunal with a direction to answer all the issues on merits without being influenced by the order made.
What is the age of this opposite party number 2?
65.
Why are you dragging him, sir?
That is why, your lordship, I am submitting to remit the matter back to the tribunal for
nothing. It will continue from where it was.
Lordship, it will continue from where it was stayed, but only observation that this order will not influence the decision of the learned tribunal while answering all the reference on merit.
Considering that the respondent to workman is 65 years old, and there has been a stay of the further proceedings in the tribunal for over 10 years now, the court is not inclined to interfere with the impugned award at this stage. To stop, all that the award does is decline to examine issue number 1 regarding the management being an industry for the purposes of Industrial Disputes Act 1947 as a preliminary, and issue number 2 is what?
Whether it is a case of retrenchment.
And whether it's a case of retrenchment, bracket issue number 2 as a preliminary issue. Full stop. The effect of this order will be that the stay granted by this court will stand vacated, and the proceedings will continue before, and the proceedings in ID case number 37 of 2011 will continue before the Industrial Tribunal Bhubaneswar. It is clarified that the impugned order dated 17th April 2012 will not be taken to be the final expression of opinion by the tribunal on the aforementioned issues. The petition is disposed of, the interim order is vacated. The copy of this order will be sent forthwith to the Industrial Tribunal Bhubaneswar.
Item 20.
20 my lords, I am for opposite but not 2 my lords.
All right, none appears as the petitioner, dismissal non-prosecution.
21.
My appearance may be recorded my lords. Okay, 2 my lords.
None appears, dismissed.
Item 22.
None appears, dismissed.
23.
None appears, dismissed.
I am for the opposite parties in 23 my lords.
All right.
24.
24 on behalf of senior counsel, Mr. N.K. Mishra is not well. Your lordship may kindly fix it to another date.
Stay on boards.
I'm for the opposite party. Workman.
Yes, stay on boards.
25.
I have prepared a chat. Well, here the pursuant to an advertisement, the petitioner made an application for allotment of a plot and accordingly made a bank draft and deposited the same before the government, and the government allotted a plot in favor of the petitioner. And as per the terms, the lease deed shall be submitted to the petitioner, and the petitioner, after execution of the affidavit, will return back to the government for execution. But the same was sent in an incorrect address, for which the same was returned to the GA department, and ultimately the petitioner requested the GA department to supply the lease deed so that he will make necessary execution.
But you didn't.
The GA department supplied the same on 18
But you were to submit the returned filled up form on 18/3, sir.
18/3, it was directed. Several cases of this nature occurred when the petitioner approached. I was required to submit on 18/3/94. I have submitted on 31st of March 1994, 15 days delay. And the government replied in the counter affidavit that several cases, your lordship may take to next page, paragraph 12, paragraph 7 of the counter affidavit. Of late, the department have formulated a policy to deal with such irregular cases, and a policy decision in this regard is being awaited. Unless the policy decision is arrived at, it will not be possible on the part of the opposite party to entertain the prayer of the petitioner. And I will take your lordship to flag M, annexure.
What is the extent of this plot? What is the measurement? 60 into 90?
60 into 90. At Ghati kya?
What's the current market value? What is the current market value?
5,400 square feet. Not 5, not less than.
My lord, the petitioner has deposited the premium and the cost of the land. Only infrastructure development cost is 50,000.
You pay the current market value, we'll ask them to allot.
Your lordship may kindly have a glance too.
This matter was discussed of last week, only ID cost. That petitioner failed to deposit, and your lordship has directed that subject to offering the market price, the current market price, the GA department will.
My lord, out of the total cost, about 50, land cost we have paid, only infrastructure development cost not deposited. And your lordship kindly the state document at annexure 8, page flag M, your lordship.
In Bhubaneswar, there is no lock-in period, correct? Is there a lock-in period?
No.
So today we allow your writ petition, ask them to execute document in your favor. Day after tomorrow, you can sell this plot, correct?
No, he's a doctor. He will have a hospital there.
Which means he can pay. If he can pay money to construct a hospital, let him pay first for buying the land. The land, what is today's market value of the land? Let him pay that. If he's prepared to pay it,
I will ascertain the matter. Let it be next week. Let it be next week.
Let him deposit the current market value. We'll give directions that they should. All right, stay on board. Just take this.
That is
next week, my lord.
Subject to availability of the land.
No, that plot is there.
Status quo order.
There is status quo.
Yes.
Must be.
That land is available on the.
We've been passing all unconditional status quo orders.
And
Everybody is enjoying.
status quo order here.
All lawyers are very happy because of those orders. Unconditional. I don't see any other high court in Delhi, Bombay and all, you'll never get orders like this. Nothing. Even a industrial award of 2 lakhs, 3 lakhs, unconditional stay.
This matter
No
will take up
other,
next week.
in all those courts, we'll make them deposit that award amount in court. Here, there is no such order. Just for the asking, notice stay. Workman doesn't know. Workman's lawyer is even one step more. He does not, if there's no stay also, the workman's lawyer does not go to recover the amount.
I think
It's
there
all
is no
new
stay
learning
order
for me.
here. There is no interim order here in favor of the petitioner.
But I'm sure, sir, your authorities would have not touched him.
No. Lease deed has not been executed. I
I
have
know.
to take instruction whether the land is still
You can
available.
take. You
I
can
will
take.
take.
All right. All right.
Your lordship is keeping it in on board.
On board. On board.
Item 27.
Next week.
Infractions. All right.
Item 28.
Where 28 is covered by your lordship judgment in Narottam Ratha.
Narottam Ratha. All right.
Item 30.
Your lordship, there is a noting that one preliminary counter has been filed, but I am not in receipt of the counter.
Let's see what the matter is.
Matter is a child was detained for, there was the father of the child, he did an insurance and the child was operated, but
These are all private bodies, sir. Apollo Hospitals Enterprises Limited is a private company.
Yes, but
these are all private companies, sir. Writ can't issue. We leave it to you to seek other appropriate remedies, sir.
Okay, fine.
Leaving it open to the petitioner to seek other appropriate remedies as may be available to petition in accordance with law. The petition is disposed. All right.
Item 31.
May I please, your lordship? The petitioner challenged the award of the learned industrial court under Annexure 1, wherein the issues have been answered in favor of me, but they have awarded only 20,000 towards the compensation amount. The relevant page is page 26.
Who's for the management?
Your lordship, I am on behalf of Mr. S. B. Jana, appearing for OP number 2. Your lordship, kindly have a glance to the issue number 3, where the Law and Labor Court has clearly said that kindly come to the last five line, that further the disputant workmen are not eligible for 1/30th pay of Group D employees, as they were engaged under a sponsored project and have not filed any proof of performing duties of Group D employees. So, your lordship, it is a time-bound project and the period of project has already been over. Then thereafter, they have been terminated.
Did you pay this 20,000?
Your lordship, in that regard.
Did you pay 20,000?
Yes, your lordship.
When did you pay?
Your lordship, I will take instruction.
Have they paid this 20,000 to you?
They have not paid me.
Your lordship, I will take instruction.
Now you pay with simple interest, all right?
Yes, your lordship.
Now you pay with simple interest.
Since 94
What's the date of the award?
94 to 2002. Award is of 2013.
So you'll get 9 years in 10 years interest, sir. We'll ask you to pay 9%.
Bigger amount, my lord.
You calculate 9% simple interest on this amount for 10 years.
You will be duly compensated.
You see, the challenge in the present petition is to an award dated 17th July 2013, passed by the Labour Court Bhubaneswar in ID case number 19 of 2003. Paragraph. The following dispute was referred to the Labour Court for adjudication in page 12 that we take from there. After pleadings were complete, the following issues were framed by the Labor Court for consideration. Take the issues from page 19, paragraph. While issue number 2 was answered in favor of the workmen, when it came to issue number 3, the Labor Court held that since they had not filed proof of performing duties of Group D employees, they were not entitled to 1/30th pay of such employees. Full stop. Consequently, a limited relief of compensation of 20,000 to each of the workmen was ordered to be paid. Full stop. Paragraph. The workmen have filed the present petition seeking enhancement of the compensation paid to each of them. Paragraph. Learned counsel appearing for respondent 2, management is unable to inform the court whether the aforesaid sum of rupees 20,000 to each of the 7 petitioner workmen has been paid. Full stop. Mr. Monty, learned counsel for the petitioners, on the other hand, maintains that it has not been so paid. Paragraph. It is accordingly directed that if not already paid, the aforementioned sum of rupees 20,000 will be paid to each of the petitioner employees together with simple interest at 9% per annum from the date of the award, that is 17th July 2013, till the date of payment, which should not be more than 8 weeks from today. More than 8 weeks from today. Full stop. If the payment is not made within 8 weeks, the simple interest at 12% per annum will be paid by the management to the workmen for the period of delay. Paragraph. It will be open to the workmen to seek enforcement of the modified award in the above terms. The petition is disposed of.
Item 32.
As item 32 is an appeal by the state. As Mr. Khuntia has requested me to ask for a short accommodation, he had to leave. Let's keep it on board Monday, my lords. The ID.
Further
case.
address not known, address has changed. What is the matter?
There's a stay, my lords.
This will
since
dispute case.
2014.
What does it do?
Next matter.
Thank you.
20,000, that's all, sir.
Please do that. His reinstatement also.
What's his age? Let's see his age. But you've not served him still. Despite notice having been issued in this petition way back on 28th April 2014, till date notice has not been served on the respondent workman. Full stop. Considering the impugned award of the Labour Court, Bhubaneswar, after finding the termination of his disengagement of the workman to be illegal, has ordered his reinstatement with a bare minimum compensation of 20,000, with arrears for just 2 years. No, with arrears of wages just for arrears for just slightly over 1 year. The court is not inclined to interfere, clarifying that the impugned award will not constitute a precedent. The petition is disposed. The interim order is vacated.
Item 33.
33, my lord, response has not been filed by the state till now. This is a case where when 61, my father was allotted the property. And they need to file a response, my lord.
My lord, they have already deposited the required demand amount.
I want
And
to
now
refund.
they want to get refund of the same. On the ground that this notification is not applicable to his father, because on the date of death of his father, on the date when the lease was granted to his father, this notification was not. And in this regard, they have submitted a representation to the director of estate, praying for refund of the amount. Since it is a refund matter, either your lordship will direct me to file a affidavit, or your lordship may direct the director to take a press to consider this matter afresh and give a final order, so that it will be open for them to challenge it in future if it is against them. Because this is a
This was
refund.
allotted, my lord, as a lower category person, my
My
lord.
learned senior has said this is a fit case for filing a response. Without the response, cannot be filed. It cannot be adjudicated without the counter. This annexure 16.
No, so this plot must be now allotted to somebody else.
No, my lord.
It
My
is
lord, what
his-
happens is this, my lord. My lord, there are 4 sons of this gentleman. One is a state bank officer, another is an engineer, another is an architect, another is today probably the Reserve Bank governor, my lord. And these poor people, my lord, they're all outside. And their father, my lord, was a clerk in the secretariat. My lord, all the good thing, but under the Grants Act, my lord, they gave the forest park and any entire area to other things. The ones that were not available to be taken by others, my lord, who didn't want to take it, they made a cooperative society called Capital Cooperative Society. These things were clerical staff then. My lord, they got allotted as a member of the cooperative society, and they were given a staggered payment basis. And once the gentleman dies, my lord, he will pay that level that is there and it will come back to him. My lord, on his death, my lord, this gentleman didn't, after his death, the family, my lord, through the eldest brother, filed an application for it. There they said, my lord, that they have to purchase, give there for their own land, my lord, to keep 56,000 rupees, my lord, 56 lakhs, my lord.
And that is
And these are not covered there, my lord. They notify that 2 notification of 3 days. The plot, my lord, was there with them till 2015, my lord.
Possession is given.
Yes, no, possession was with us, my lord.
The possession is there, lease deed has already been executed. For making it freehold from leasehold, right? A consent fee is required to be deposited. That he has deposited. Now he is
Yes,
seeking
we paid,
refund
my
of
lord. We
that.
want refund of that, my lord, because these are, when the father was allotted.
On the ground that they are not liable
My
to
lord,
pay
the
that.
statute itself, the agreement as well as their own notification provides for that. That,
What is where in Bhubaneswar?
yeah, the statute.
My lord, this is a very meager amount in Bhubaneswar.
Meager,
the consent
obviously,
fee
my lord,
more
it's meager.
than crores. The people are depositing.
Yes,
That is
but if
the-
you want to keep my own
learned
property, you have to
senior
buy
knows
that much.
Better than me. So.
And
it
my
is-
lord, may kindly see it is allotted as a low category, low income good capital.
Bhubaneswar is the heart of Bhubaneswar.
Yes,
It's a heart of Bhubaneswar.
that
Bhubaneswar.
61, my lord, it was nowhere.
My lord, we are nothing to get from them. We have nothing to get from them. They have already deposited. They want refund on this particular ground. It is near Bhubaneswar station.
That Bhubaneswar station wasn't there then.
No.
Which was when it is allotted.
Today it is
61.
The value of this property is
Yes,
something else.
We are not concerned with
But
that.
value-
Whether
that
they
means-
will be entitled to get refund of this
Yes.
consent fee, that is the point. For
That is the pointed
consideration.
issue.
In that regard, I would like to pray your.
But they have
that-
put Forest Park and this area at the same time, same rate.
That is, Bhubaneswar Forest Park, Station Bazaar is more commercial, better commercial area than Forest Park.
I'll take my lord, so 2 notifications that are there, their own notification. How much I am to pay?
So far as applicability of these notifications are concerned.
That is
I
the
have to
point.
take instruction.
That is the only point.
That is what I am saying, that if a lordship will direct the director to take, to consider these, his application in the light of those notifications, then I think his
10.
grievance will be redressed.
10.
All right. It appears that the petitioner's representations seeking
My lord,
refund
that
of
is
the.
2003 it is written, but I think that is 2013.
Yeah, let me make a fresh one. Representations asking for refund
Last annexure.
of a sum of rupees 59,98,762, which was
50 page,
Annexure 16, Raja.
52, and 16.
paid by.
No, it's 2013, my lord.
Is it
It is-
13? Wrong
They
is
have wrongly stated as 2000.
Has to be 13.
After the government decided that the circulars offering concessional premium were not applicable to the petitioner, have not yet been dealt with on merits by the government at any stage. Full stop. Even in the present petition, despite notice having been issued, no notice was not even issued.
2014, my lord.
I think, yes, issue notice, yes. Order dated 8th May 2014.
On 8th May 2014, till date, no reply has been filed by the government. Paragraph. In the circumstances, the court directs that the petitioner will make a fresh representation to the government, not later than 1st March 2023.
My lord, government, not the government, Director of Estates.
To the Director of Estates. All right.
GA department.
Of Estates and additional secretary to government, GA department.
Yes.
To the Director of Estates, come Additional Secretary, come General Administration Department, Government of Orissa. Bracket opposite party number 2, not later than 1st March 2023, enclosing all the relevant documents and urging all the pleas urged in the present petition as well as other pleas that the petitioner may have in accordance with law. 2, after giving the petitioner a hearing on a date to be informed to the petitioner at least 1 week in advance, opposite party number 2 will pass a reasoned order and communicate it to the petitioner not later than 3rd July 2023. If aggrieved by such order, it will be open to the petitioner to seek appropriate remedies in accordance with law.
The court is not expressing any opinion.
The court is not expressing any view on merits. All right.
My lord, then I'll request my lord to for my lords to refer to page 52, my lord, which themselves say they themselves say that.
Your lordship
I
has
don't
given
leave it
liberty
at
to
that.
them to approach the authority with all the documents.
Yes.
All right. Item 34.
Deeply obliged.
All right.
Item 34, my lord, may be permitted to be withdrawn.
All right.
My lord, item 34, I am on behalf of the opposite party bank. My appearance may be noted.
All right. Dismiss is withdrawn.
35.
None appears to be so.
Item 36.
In item 36, I am for the petitioner bank, my lord. Here in this matter, the opposite parties have availed a loan and on non-payment and it has been become as classified as NPA, a DRT case has been filed. During pendency of the DRT case, the borrowers have applied for a settlement under the Lok Adalat. My lord, I directly want to draw your kind attention at page 82 of the writ application, my lord.
No reply has been filed.
My lord?
No reply has been filed by any of the parties. You say the present petition by the bank questions an order dated 17 January 2010 passed by the Debt Recovery Tribunal Cuttack in OA number 519 of 2012 at a special Lok Adalat. Full stop. The contention is that the petitioner was had never consented to the said order. Paragraph, while issuing notice in this petition on 8th August 2014, the court had stayed the said settlement reached and noted in the said order dated 17 January 2014 of the DRT. Paragraph, till date, no reply has been filed by any of the respondents to contradict any of the above assertions of the petitioner. Full stop. In that view of the matter, the impugned order dated 17/10/2014 of the DRT in OA number 519 of 2012 is hereby set aside and OA number 519 of 2012 is restored to the file of the DRT. If not already, if the said OA is still pending, then it will be proceeded with in accordance with law by the DRT. Full stop. It will be listed for directions before the DRT on 1st March 2023, on which date the petitioner will appear along with the downloaded copy of this order. The petition is disposed of. Obligation.
Item 40.
Item 40, I am appearing for the sole opposite. Petition is not mentioned over here.
Lordship,
Because this is lies for the DRP or the section 7.
Lordships have been pleased to pass orders in respect of matters with similar cause of action. Wherein the petitioner's OTS application may be considered, considering the money already paid, which is a sum of rupees 25 lakhs, which was a condition.
Same order. I think 16 February, you can make the 1st March.
Well, the OTS scheme is not available now in the bank.
Oh, in your bank, there's no OT scheme.
Not available.
Oh, then we can't pass this order. You say against the impugned order of the DRT, there's an efficacious remedy available to the petitioner before the DRET, permitting the petitioner to avail of such remedy in accordance with law. The petition is disposed of. This order is being passed in light of the submission made on behalf of the opposite party bank that at present there is no OTS scheme of the opposite party bank.
There are liabilities in more than
Interim orders vacated.
52 lakhs more than that.
Return it.
Item 41.
On behalf of Mr. Pradhan, I may be permitted to submit mine. My lord, the petitioner was granted leave in respect to a piece of land by the annexure 1, my lord, for the purpose of running a automobile servicing center, my lord. Subsequently, that was cancelled by the collector on the ground that he has no jurisdiction to pass the order, and the jurisdiction lies with the government, my lord. Therefore, the petitioner has approached this honorable court, and this honorable court has directed to forward the application to the government. I have quoted the operative part of the order in the previous writ petition, my lord, at page 7, my lord. Page 7, para 5, para 5, that operative part of the judgment, my lord. We therefore direct that the application for grant of leave filed by the petitioner is now to be taken up and dealt with in accordance with the law.
That was passed in 94.
My lord, till that the
When did you come back to this court? After the 1994, when did you come back to the court?
because no action was taken.
When did you come back, sir?
2014,
How many years?
after 15 years.
After 20 years, my lord, that's.
Why? 20 years. Previous order. But it's still due 1994, emergency number 184 to reduce pay. So clearly the petitioner's part by it has not been satisfactory. According to the court.
May I,
Item 42.
may I pray, my lord, in item 41, my lord? My lord, liberty may be granted to approve the approval.
That's not go on.
42.
May I please, my lord? My lord, this matter pertains to Hindu Religious Endowment Act, my lord. My lord, similar matter is pending. May I pray this matter may.
Let's deal with it here. What is the matter about?
My lord, because that matter, if won't be heard, my lord, this matter cannot be heard, my lord. My lord, because in this matter, the only question arises here, whether the institution is a public institution or private institution. My lord, that matter is pending. My lord, unless that matter is not decided, no hereditary, whether hereditary trustee can be appointed or not, that will be decided, my lord. For which I pray that matter may be tagged with this matter. 8149 of 2007, my lord.
For the petitioner.
My lord, I am for the petitioner, my lord.
Call for that. See, stay on board. Call for that. Petition civil.
My lord, that is 8149 of 2007. Grateful.
Item 43.
I am appealing for opposite party.
Item 44. 45. 46. 47.
Yes, 47, I am appealing to the petitioner. My instructions, the loan amount has already been settled. There is no cause of action survives.
My lord, I am appearing for opposite party bank, my lord. My appearance may be recorded, my lord.
Obliged.
52.
48.
Item number 52.
My lord, item number 52 matter has become infructuous, my lord.
My lord, item 48. My lord, I am for the opposite party in item number 52, my opposite party.
48.
In 48.
48
48 are infructuous.
Your lordship may only note my appearance. 48.
$53.
53, my lord, I am for the petitioner. The batch case has been decided, my lord, my lord's order.
Narottam Rata.
My lord has decided. My case is similar to this, in the same mauja.
Narottam Rata. Same.
54.
54, my lord, infructuous.
All right, infructuous.
Player already been complied with.
All right. Appearance of not even noted. 55 also same. All right, 55 also.
Yes, appearance of not noted.
All right.
56.
56, my lord. Here the petitioner is the secretary of a society, my lord. All along the prayer has been made before the authorities for settlement of land. Admittedly, it's a government land, my lord. And the petitioner have constructed their house over the said land, my lord, and they have been granted with all the amenities, my lord, including electricity and water, everything, my lord. Here under Annexure 11 series at page 83.
So there are separate provisions in the law for settlement and all.
My lord.
You have to go under those provisions.
We'll have to.
Permitting the petitioner to avail of other remedies as may be available to the petitioner in accordance with law, the petitioner is disposed of. All right.
58. Item number 58.
On behalf of SP Madhi, next week.
Why? Why, madam?
Mr. Madhi, some other court.
Sorry?
Mr. Madhi? No, other court.
Ask him to come. Tell him there is also this court. All right. Please ask him to come, madam.
59.
None
Item
appears
number 59.
dismissed. None appears dismissed.
60.
Covered by this your lordship judgment. Your lordship. The order passed under section 33 2B of the ID Act with under order passed by the London Labour Court under section 33 2B ID Act without considering the judgment of the
All right. All right. Same order.
Case number has to be lordship.
The date, 1 minute, just show me that. Show that order. 6th March is fine. Yeah, all right.
61.
My lord, no instruction.
No instruction.
All the three matters.
All right, all right.
62.
May I please, your lord? My lord, in this case, the conducting counsel, Mr. A.S. Pang, already has an expert. Therefore, your lordship may put up this matter any other date. He will engage the case lawyer.
Next 3.
My lord, the interim order dated 24/11/2014 may be continued, your lord. Order dated 24.
If you wanted to continue, you must argue today.
My lord, he has expired, therefore the
That's all right.
party will engage.
When did he expire, sir? When did he
Therefore, your
expire?
lordship-
When did he expire, sir?
My lord,
When did he expire?
it has not been expired till date.
You don't even know the date when he expired. What is the impugned order? Passed by whom? Impugned order is passed by whom, sir?
Impugned order passed by the OP number 2.
Who's who?
Additional Sub Collector Bhubaneswar.
Appealable order then.
My lord, he is the appellate.
Additional sub-collector appealable order, no?
No, my lord, he is the appellate authority.
Under
OGLC Act. And in this case, your lordship already has directed to give the that AA case record before your lordship. Item 62.
Mutation application. In mutation case. So mutation is what?
In some case, the appeal lies before the sub collector.
But that's the order the sub-collector which is challenged.
Then he has to go to Board of Revenue under.
Board of Revenue, no?
Yes, yes.
I see. Against the impugned order of the sub-collector, a remedy is available to the petitioner before the Board of Revenue. Permitting the petitioner to avail of such remedy, the impugned orders, the petition is disposed of. If such petition is filed before the Board of Revenue not later than 1st March, accompanied by an application for condemnation of delay explaining the delay on account of the petition in the present petition, it will be considered in accordance with law by the Board of Revenue. The court clarifies it has not expressed any view in the matter. If the petition is filed within the date indicated, by the date indicated, along with an application for interim relief, then till such time the Board of Revenue passes an order in the said application. The interim order passed with this court on 24th November 2014 will continue. Petition is disposed of.
63. My lord, till then no course of action shall be taken.
That was close.
Item number 63.
None appears dismissed. Interim order petition.
64.
Item 64, my lord, I am appearing for the petitioner. I have filed the memo for withdrawal. The matter has already been settled and no dues.
Memo taken on record disposed of. It's better.
65.
None appears dismissed.
66.
My lord, I am for the opposite of the bank, my lord.
All right, none appears with the petitioner dismissed. Interim order vacated.
67.
On behalf of Mr. Bekenag, no instruction.
No instructions dismissed.
68.
None appears dismissed.
70.
7. My lord, item 70 covered matter, order of ASO, my lord.
Narottam Rata.
Yes, my lord.
Same order.
71.
Item number 7 is also covered matter, your lordship. But first of all, there is a substitution application. I have filed.
All right. Substitution application is allowed. And then Narottam Rata.
Lordship. Order passed by the settlement officer.
71.
All right. Same order.
72.
It's also covered matter, your lordship. Order passed by the ASO.
All right. Same order.
73.
May I please, your lordship? My lord, on behalf of Mr. Vasudev Pujari, my lord, 1 week time may be allowed to file the reply on additional affidavit.
Let's see what the matter is. No question of further replies and also.
My lord, because in counter, they have already stated that CY1, that the plot number is so and so. After getting the rejoinder, they have filed the additional affidavit. That is wrong. Another one is correct. Have a
All right.
glance.
Anyway, you'll stay on board, whatever you file. All right. Yes.
My lord,
Stay on board.
You file the affidavit tomorrow. Yes.
my lord. Deep low pleasure.
75,
None appears dismissed.
76,
None appears dismissed.
76, I am for the opposite.
It's for the opposite party. Interim order vacated.
And the account has been settled by the petitioner.
All right.
77,
Item 77 matter has been settled.
All right. Infractuous dismissed.
78,
None appears dismissed.
79,
This matter, I am for the bank.
Okay. None appears for the petitioner dismissed.
80,
Also,
Same
I
order.
am for the bank. my
Same
lord.
order.
81,
My lord, in this read petition of petitioners challenging the inaction on the part of the opposite party in disposing of my application. My lord, fact is that petitioner's great grandfather was the.
That's okay. Miss Case 8 of 2012 is pending before the administrator.
My
It is stated that the petitioner's Miss Case number 8 of 2012 is still pending before the respondent, opposite party and chief administrator, Shri Jagannath Temple Puri. If that be the case, then the said petition will be now disposed of by the chief administrator, Shri Jagannath Temple, after hearing the petitioner, on a date to be informed to him at least 10 days in advance, by a reasoned order, within a period of 6 months from today, and in any event not later than 7th August 2023. Copy of the order will be made available within a week thereafter. If agreed by such order to be open to the petitioner to seek appropriate remedies in accordance with law, the court clarifies it has not expressed any view in the matter.
82,
None appears dismissed.
83,
None appears dismissed.
84,
Same order.
85,
My lord, in this case, the prayer portion of my writ has already become redundant, my lord.
All right.
My lord, if your lordship, only point to be determined is, my lord, regarding the compensation amount, my lord. Lord, let that be observed.
Meaning what?
My lord, the writ was filed regarding the construction of high power electric transmission tower over the land of the petitioner without the petitioner's permission, my lord. Lord, regarding that, it has already long gone. The process has already concluded. My lord, regarding the compensation amount, that is only open, my lord. My lord, no compensation amount has yet been.
You
given.
seek other remedies, sir. Whatever, if you have other remedies.
My lord, Indian Telegraph. My lord,
Of the Indian Telegraph Act.
Correct. Permitting the petition to avail of alternate remedies available to the petition in accordance with law in regard to the prayers that still survive. The petition is disposed of.
My lord, I am the opposite party number 2 and 3, my lord. My application.
All right.
86,
None appears dismissed.
88,
None appears dismissed.
We are for the OP number 3, my lord.
All right.
That's
90,
None appears dismissed.
91,
Same order.
92,
Same order.
93,
My lord, 93, I am on behalf of a bank opposite by number 2.
All right. None appears to the petitioner. Notice appearance dismissed for non-prosecution.
92, my lord.
92.
My lord, 92, my lord. Here I have challenged the 13-4 notice, my lord.
You have an alternative remedy, sir. Permitting the petitioner to avail of the alternative remedy in regard to the prayer made in the present petition.
Oh, bless me.
The petition is disposed of, the interport is vacated. The amount paid by the petitioner will be accounted for by the opposite party bank at the appropriate stage.
Oh, bless me.
93.
94.
94, I am on behalf of opposite but not to bank, my lord.
All right. None appeals to the petitioner. Dismissed for non-prosecution.
95.
None appeals dismissed.
96.
None appeals dismissed.
97.
My lord, this is a minimum wages matter. Maybe assigned to appropriate bench, my lord.
Which bench? This is only the bench, sir, 2015. This is only the bench.
My lord,
Now come to the best submission you have. One submission over. Now next submission.
next submission, actually, file not with me, my lord.
So one submission without file.
My lord.
Now, now only the problem starts.
I know that is a minimum wages matter, my lord.
File is missing, so petitioner is unable to make submissions. Dismiss for non-prosecution with liberty to revive the petition if the file is found. All right.
98.
My lord, item 91, my lord. Kindly. Yes, in this case, my lord, petitioner has been died. 2 weeks time to.
No. All over, sir. When did he die? He must have died long ago. It's okay. You passed the order already. Yes.
My lord, senior misunderstood.
98.
None appeals dismissed.
99.
OP was working as pump helper. There was a VRS scheme floated by the corporation. He applied and his VRS was accepted. Annexure 5 page 18. VRS application of the OP was accepted with effect from 30th April 2003. After 8 years of this acceptance, my lord, he filed a 33(2)C application before the labor court claiming salary back wages. My respectful submission is that, my lord, 33(2)C is more of an executing proceeding, my lord, unless and it is seriously disputed by the management, my lord.
Have you served him?
Yes, my lord. Somebody has appeared.
Who has appeared?
Yes, I am confirmed.
So how can you get it, sir? Without an actual industrial dispute, you can't have 33C2. There must be an award. Only then 33C2 will happen.
They have been adjudicated at that time, your lordship. That was not been hesitated by the opposite, by the petitioners. And only 19,000 back wages. A workman has worked admittedly, and the back wages only 19,000.
Whatever, sir. There's been a stay here. You say the challenge in the present petition by the management is to an impugned award dated 30th September 2014, passed by the Labour Court Jaipur in industrial dispute, miss case number 17 of 2012, directing the petitioner in the above application filed by the workman under section 33 bracket capital C bracket 2 of the Industrial Disputes Act 1947 bracket ID Act to pay a sum of rupees 17,000. And sorry, 19,980 as arrears of salary. Paragraph. It appears that accepting the the case of the petitioner management has been that it accepted the workman's VRS application and he was retired from 30th April 2003 after accepting all the dues. So after waiting for 8 years, he filed the application under section 33 capital C2 of the ID Act for recovery of a sum of rupees 99,020 as CPF and salary of 19,980 for the period 1st May 2003 to 22nd May 2004. Paragraph. The Labour Court appears to have adjudicated the above application without noticing that there is no initial determination of the claim of the workman in an industrial dispute case under the ID Act. Stop. Absent such a determination of the entitlement of the petitioner in substantive proceedings, comma, an application under section 33 capital C bracket 2 of the ID Act could not have been entertained by the Labour Court. Stop. On the above short ground, the impugned award is hereby set aside. The writ petition is allowed, no orders is to cause.
The liberty can be given, my lord.
That is always there. Sir. Yes.
Unless your lordship will give liberty,
No.
he cannot approach it.
Whatever, sir. Whatever. Yes.
Item 100.
None appears dismissed.
101.
None appears dismissed.
102.
This is an application for this writ has been filed challenging the order by annexure 4, rejecting the claim of the petitioner, refusing granting no objection certificate in respect of a non-existent deity. The petitioner has approved the Learned Commission of Endowment way back in 2014
for NOC for a sale deed.
NOC for executing a sale deed.
Now the circumstances all change, sir. So notwithstanding the impugned order, you can make a fresh application.
That observation method.
You say the impugned order of the Commissioner of Endowments declines the prayer of the petitioner for issuance of a no objection certificate in an application filed under section 19 capital A of the OHRE Act. Stop. Since it is more than 8 years of the passing of the aforementioned order, and with clearly the land values having changed and circumstances also having changed, it is clarified that notwithstanding the impugned order of the commissioner, it will be open to the petitioner, if the circumstances so warrant, to file a fresh petition under section 19 capital A of the Commission of Endowments in accordance with law. The petition is disposed of there.
103.
My lord, 103, I prayed that the matter may be kept on board, my lord, may be taken up.
103.
My lord.
This is not Narottam Datta.
No, this is not covered by Narottam Datta. This is also an OGLS matter.
All right, stay on board.
104.
104, my lord, the petitioner has challenged the order of the Labour Court, where my lord, the instruction is that the management was not functioning since 2013, and now it is functioning. My lord, my prayer is that may refer the matter to Lok Adalat.
My lord, I am for the opposite party.
You're agreeable for Lok Adalat?
My lord, in the second case, my lord, there was a stay subject to compliance of 17B, but
Your lordship, opposite party is already complied, but the petitioner has not complied this 17B. By ID Act. Award has been passed 7th July 2012.
So what's your response to this plea that 17B has not been complied with?
that has not been complied with.
Then where's the question? You first comply with that.
May refer it to Lok Adalat so that it will be settled, my lord.
No. First, what is the amount? We don't even know.
The amount is one.
You calculate all the 17B wages you have to pay. What will be the amount? Have you done the calculations?
Sir, the Labour Court has been passed 3,02,601 OP number 1 and 2,53,951 in 16th April 2015.
17B. What is the calculation for 17B? How much is owed to you? Are you aware? This is the item number.
104.
You better make a calculation and show us. Next week we'll call it out first.
Your Lordship.
All right, we'll stop here. Stop here.